Good morning and welcome to day 2 of the Association of Justice and Treatment Professionals annual Justice and Treatment Partnership Conference. This is the second day and my name is Kofi Barnes. I'm going to be your chair. Your host for today is going to be Dennis Riley and Jennifer Graham. And I'm going to tell you something about Dennis and Jennifer. I'll start with Dennis. Dennis Riley is the statewide drug court coordinator for the New York Unified Court Systems Division of Policy and Planning. Previously, Mr. Riley served as project director at the National Drug Court Institute, where he co-authored the Drug Court Planning Initiative, and as the director of operations for treatment court programs at the Center for Court Innovation. Prior to joining the New York Unified Court System, Mr. Riley worked for the Connecticut, I'm stuck on the words, Judicial Branch as a special deputy sheriff, trial court clerk, pretrial services officer, supervision officer, and court planner, and was a founding team member of Connecticut's first three drug courts. Mr. Riley served as director of the Brooklyn Treatment Court and the Problem-Solving Courts Coordinator for King's Supreme Court. Mr. Riley is a Reclaiming Features National Fellow and has served as an expert consultant to National Drug Court Institute, the Justice Management Institute, the American University Drug Courts Program Office, the National Council of Juvenile and Family Court Judges, the Center of Juvenile Justice and Delinquency Prevention, the Bureau of Justice Assistance, and the Center for Substance Abuse Treatment at SAMHSA. Mr. Riley is a graduate of the University of Connecticut School of Administration and Management, the University of Denver College of Law, and the University of Amsterdam School for Executive Development in International Relations. And then Jennifer Graham is your host for the afternoon. Jennifer Graham is an assistant crown attorney and has been in the Peel office for 8 years. Jennifer has been on the organizing committee of the Association of Justice and Treatment Professionals since it went live in early 2021. She has also been an HSJCC committee member since the spring of 2019 and has been the co-chair of the Peel Dufferin Table since September 2020. Jennifer is a member and a strong leader of Peel's Drug Treatment Court. Now, I would like to acknowledge that we are broadcasting from Brampton, and we are meeting on Aboriginal land that has been inhabited by Indigenous peoples from the beginning. As settlers, we are grateful for the opportunity to meet here, and we thank all the generations of people who have taken care of this land for thousands of years. Long before today, as we gather here, there have been Aboriginal peoples who have been stewards of the land. In particular, we acknowledge the Anishinaabe, Huron-Wendat, Haudenosaunee, and Ojibwe and Chippewa peoples, the land that is home to the Métis, and most recently, the territory of the Mississaugas of the Credit First Nation, who are direct descendants of the Mississaugas of the Credit. We recognize and deeply appreciate their historic connection to this land. We also recognize the contributions of the Métis, Inuit, and other Indigenous people have made both in shaping and strengthening this community in particular, and our province and country as a whole. As settlers, this recognition of the contributions and historic importance of Indigenous people must also be clearly and overly connected to our collective commitment to make the promise and challenge of truth and reconciliation real in our communities, and in particular to bring justice for the lives lost in residential schools, as well as all the murdered and missing Indigenous women and girls across our country. The views that are expressed by the speakers during today are those of the speakers. They do not necessarily reflect the views of AJTP or IADTCP, and we are just pleased that our speakers are prepared to speak to us today. And the Q&A is where you should connect with the speakers. We like to engage. And Dennis, over to you.
Thank you very much, Your Honor. It's my great pleasure to serve as co-host today for the Association of Justice and Treatment Professionals and the International Association of Treatment Court Professionals annual conference. I've been a member of the International Association for over a decade, and it's my great pleasure to introduce Assistant Deputy Attorney General Jeremy Akerstream, who has more than 20 years of criminal law experience, beginning as defense counsel and then serving as public prosecution service in all levels of the Manitoba courts. Attorney Akerstream is an active supporter of drug treatment courts nationally and now serves as the chair of the Canadian Association of Drug Treatment Court Professionals. As you know, their goal is to raise public awareness and impact public policy to reflect the necessity of drug treatment courts. Also, in my search of the internet, I learned Attorney Akerstream is also an ardent supporter of the Jazz Winnipeg organization. Good morning, Attorney Akerstream.
Good morning. Thank you so much for that introduction, Dennis. Greatly appreciated. Good morning, everyone. I'd like to begin by acknowledging that I come to you from Treaty 1 territory, the traditional homelands of the Anishinaabe people, and then the homeland of the Métis people. We are very pleased to be here today, both as a representative of the government of Manitoba, as well as a member of the Canadian Association of Drug Treatment Court Professionals. And special thanks to Dennis for his extra research. I am, in fact, also chair of the board of directors of Jazz Winnipeg and have been for the last several years. So I was just told just before I started that I was going to give a balanced presentation. I look forward to that. But certainly what I want to do is give you just a few things. Number one is we're going to give you a little bit of a history of the drug treatment court here in Winnipeg and in Manitoba. I'm going to talk to you a little bit about some of our challenges going forward, some of the lessons that we've learned, and some of the challenges that we have going forward. And of course, at any point, if you have a question or concern, please feel free to ask. I may not have an answer, or at least not an accurate one. It's always hard to know. Anyway, as you've heard, I'm now the Assistant Deputy Attorney General for the province of Manitoba. And I just want to tell you a little bit about Manitoba. I'll skip over the weather and just tell you that Manitoba is a province right in the center of Canada, just a little bit north of North Dakota, for those of you who are from the United States. And we have about 1.35 million people in our province. What's significant for us is that not only do we have 1.35 million people, but about 21 to 22% are Indigenous. Unfortunately, I can tell you as Justice Minister, it's a very difficult, it's a part of the Justice Ministry, it's a very difficult position to be in, but approximately 70% of our incarcerated population are Indigenous. So you can see that's over 3.5 times the general population number. And we don't keep specific stats, but we think between 80 and 90% of our justice participants, if you want to use that word, are also Indigenous. I can tell you, because recently we've had discussions with respect to devolution of family services, that with respect to the apprehension of children under the Child and Family Services Act, 88% are Indigenous. So when we're speaking from Manitoba, when I'm speaking to you from Manitoba, the idea of reconciliation is paramount for us at this time. And it's clear, very clear, as you've heard from those numbers, that we have to take some significant steps to start to alleviate the overrepresentation of Indigenous people in our justice system. So I'm going to get to that in just a few minutes, but I want to talk about a little bit about our drug treatment court here in Manitoba. We actually have two now. We started off with the Winnipeg Drug Treatment Court in 2006. And I won't get into a lot of the details for you because many of you are familiar with the drug treatment court process. Our first client accepted way back in 2006, graduated in December of that same year. Ours is one of the few federally funded programs in Canada at that time. And we were very, very happy when in 2015, after sort of some dispute, we opened the door and the province of Manitoba has now taken responsibility for the program. So there's been an evolution of the program, but with a sort of a brief exception, it's been 15, almost 16 years running now, and very, very excited about it. So as you can see from that slide as well, in September of 2019, we started a drug treatment court in the western part of Manitoba. Some of you out there will be harsh critics, but we call it the Westman DTC. For the record, that was not my vote. It's in the city of Brandon, which is a city of approximately 50,000 people. We'll talk about that momentarily because we're going to talk about some of the challenges that we had faced there. I always like to put this one up, especially when I'm dealing with national or international conferences, because I'm always curious about who we accept. So possession, the reality is we have very few people, we've had very few people that are simply possession charges. We've had one or two, but the reality is That's usually a plea bargain as a consequence of other charges. Obviously, many of the individuals that come into the program have possession charges, but they're usually in association with some of the other charges that you see here. Surprisingly, at least in Manitoba, the majority of our drug treatment corp participants are traffickers, low-level drug traffickers. And I think that's common across North America, that you have individuals who are indebted to drug dealers, and they go out and they sell drugs, and they're often paid. They either repay that debt. We used to, I'll give you an example, when we used to have a significant crack cocaine problem here in the city of Winnipeg, we used to see individuals that used to get paid three rocks of crack cocaine for operating the drug line for a shift. So that's really been a significant part of our focus there. And part of, there's a lot of reasons for that, both from a law enforcement perspective as well as from a treatment perspective. Clearly, though, the individuals who are involved are doing so based on, predicated solely on their addiction. Break and enter, of course, that's always a controversial one across the country and across North America. And lots of forgery and fraud as well. So just a sort of a general makeup, but to be honest with you, going through it, I would guess that probably 70% right now of our individuals in the court are traffickers. Going to go really quickly through the eligibility piece. Just a nice comparison for some of you who are familiar with the program. Obviously, criminal organizations is something that we stay away from. Violence or weapons. Was the offense solely motivated by profit? And again, that's that difference between individuals that are, for example, selling or trafficking because of addiction versus those who are commercially motivated. We also look at things like near a schoolyard, the involvement of an individual under the age of 18, and a number of other factors. Immigration continues to be an issue that we struggle with just because of the law here in Manitoba and, of course, in Canada with respect to deportation. And of course, we also look at any other serious criminal charges, whether federal or provincial. Part of the criteria for this, I should tell you as well, is that we have significant concerns, not only about the public interest, but also because we're concerned as well about the other participants and the staff, and ensuring that their safety is paramount for us. We want to create a safe environment and an environment where treatment can take place in a manner that is not going to cause concerns for personal safety for any of the participants or for our staff. Eligibility, number of different criteria. I'm just going to go through a couple of them here very quickly, just again for comparison purposes. Really our ideal candidate, and I can tell you, I actually ran this program for over 10 years before my current job, and we're really focused on individuals who, and what I've always said is that the ideal candidate, and this will come as no surprise, is a person that, but for their addiction, would not be part of the criminal justice system. That's the ideal candidate. I'd like to think that we had a few of those, but we certainly had a number of people that the reality is that, but for their addiction, they certainly wouldn't be in the trouble that they got themselves into. And I think probably all of you out there can relate to that. Presenting as motivated and willing to commit to the case plan developed for them. We actually have a very rigorous program in Winnipeg, and I'll talk about that in just a moment, and willing to engage in all aspects of the drug treatment court programming. So we have a hierarchy of needs. I'm going to just skip through this one very quickly. All of you out there, I'm sure, are going to be familiar with this hierarchy of needs. Starting at the very bottom, safe housing. Massive challenge for us, both in Winnipeg and in Brandon, for very different reasons. And I'm sure, and I'll just talk about for a second, because I certainly am not going to sit and talk to a group of treatment court professionals about what this hierarchy looks like. This is the hierarchy we use in Manitoba. I think it's fairly standard for the most part across most treatment providers across North America. So we've seen two really interesting things. In 2012, we actually had a housing project where we had funding, we had a house. So we would take individuals who didn't otherwise have access to safe housing and put them into that house. Yeah, there's the usual drama. I'm not saying it would have been a great reality TV show, but we had a few things here and there happen. But for the most part, it was an incredibly successful program. And so as you might imagine, we did an evaluation and everybody was in agreement that it was an incredibly successful program, really met the needs of a very significant group of our target population. And we thought that it was going incredibly well. Our evaluation numbers looked a little bit different as a consequence. Things are going great. And as sometimes happens when things are successful, the funding was cut. So we lost our house, but housing continues to be a problem for us. So we're dealing with two different issues. So in Winnipeg, which is a city of approximately 700 or 750,000 people, the largest metropolitan area in Manitoba, we are seeing that there has been a significant cost of housing, like all other areas of North America, for example, and the Western world, really. We've seen that housing prices have continued to grow at a rate that's well beyond what the wage growth is. The consequence of that, of course, is that to find safe housing, we have to find affordable housing as well. And that's been an incredible challenge, because not only have we seen the rise in terms of the real estate market, which again is not unique to Winnipeg or certainly to Manitoba, but we've also seen a corresponding rise in rental rates. And so safe housing and affordable housing really have gone hand in hand in Winnipeg. In Western Manitoba, the Westman Drug Treatment Court, as we like to call it, we've seen a very different phenomenon, of course, which is that it's just hard to find housing, period. It's a little bit more affordable. As you can imagine, a city of 50,000 people, the affordability is much higher, much more attainable than it is in Winnipeg, for example, or many of the cities that you're from. However, finding housing and finding landlords that are willing to work with us has been an incredible challenge. So two very, very different processes, but as you can see from our perspective, likely not something that's new for any of you, and a very similar experiences, it would be my quick guess. I should just point out as well that in that hierarchy, as Assistant Deputy Attorney General, I should point out that justice is not in that hierarchy of needs. It always bothers me on a personal note. It sort of interferes with my self-importance. But the reality, of course, is it's not. We're going to talk about that involvement in just a second. So at least in Winnipeg, our drug treatment court involves, as you can see, the regular court appearances, the random drug testing, client-centered treatment, cognitive behavioral therapy is really a staple for our program here, counseling, life skills, employment, et cetera, et cetera, et cetera. And I'll come back to that one in a minute. Sadly, we have not done a significant evaluation since 2015. But just to give you a brief sense, and again, I'm not trying to compare our program to others, but I personally always find it interesting when I have the chance to learn about other programs. About 30 years of age, give or take, is our average age range. Our number that we're concerned about is that only 46% are Indigenous. And as you've heard, when we are in a situation where we think almost twice that number within the criminal justice system are Indigenous, we are very concerned about getting that number higher. And to talk to you about that in terms of challenges coming forward, it has increased significantly, but once we hit that 50% number, it sort of has evened out. Most are single and unemployed, which is not necessarily surprising. Education, grade 11 or more, actually surprising number that we have a number of high school graduates now. And again, you'll just see there that in this case, 58% of people who the main charge is drug trafficking. So just a bit of a brief profile for those of you who are dealing with drug treatment courts in your jurisdictions. Continuing again, 81% of participants have a criminal history. 31% have a record of violence. Those are very, very minor areas of violence. Just so you know, sort of our ideal candidate here is a high risk at the social level and a low risk at the violence level, because again, we're concerned about the other participants. Interestingly, in 2015, I remember those days, the primary drug of choice is cocaine. Just so we're clear, I don't remember this personally, but I remember the profile of the clients. Methamphetamine. And so I'm just going to tell you just very quickly, because I always find this fascinating as well as we go from jurisdiction to jurisdiction. I'm very, very happy to tell you that up to this point, we have not had a significant problem with opioids in Manitoba. We had a very brief time in 2019 or so where opioids had become more important in the drug scene and had become, I won't say the drug of choice, but we had seen a significant increase. That's gone away. Surprisingly, for whatever reason here in Winnipeg and then the prairies, crystal methamphetamine is the #1 drug. And it's presenting a challenge for us, because what we're seeing is, and what many of you are seeing, I'm sure, is the idea of meth psychosis, that after a long period of time, individuals who are using methamphetamine are becoming more and more violent and more erratic. It's presenting an incredible challenge for us. And I know that some of you will be talking about this during the course of the day, because we have traditionally not accepted individuals with significant violence, either as a charge or on the record. However, what we're seeing, at least in Winnipeg, is these sort of random acts of violence of individuals who are in a meth-induced psychosis. And we are challenged about how we're going to deal with that and how we'll continue to deal with that. So from our perspective, we need to expand, and we need to look at that expansion based on the needs of our jurisdiction. So I don't think that's a unique challenge. I think many of you have grappled with that issue. I know in speaking to others across the country, that's a challenge that has been widely debated, and there are a variety of viewpoints on it. I'd be curious to know about the United States approach, but and I'm sure it's very locally, of course, but a significant challenge for us as we deal with the continuing use of methamphetamine. It also goes back to the issue of housing because unfortunately, I skipped over weather before when I was introducing you to Manitoba because, of course, I wanted some of you to come in and move here. But I'll tell you right now, it's minus 20 degrees Celsius this morning. And for methamphetamine, we know that there's a significant population of individuals who are homeless or at the lower end of the socioeconomic status who are using methamphetamine because, and we've actually had somebody tell us this, if I use methamphetamine, if I use meth, I keep moving, which means I stay warm and I stay alive. And you can imagine minus 25 last night. You can imagine, maybe you can't actually, I'm not sure that you ever truly could, but you can imagine what individuals who are homeless are facing in our city. It's a challenge of survival at many levels. And so when we saw methamphetamine come into our city, we saw it moving down significantly. So cocaine was more of a middle class and lower middle class drug, which I'm sure is true in many jurisdictions. With methamphetamine, we've seen that being pushed down the socioeconomic ladder. So as we've started to treat people for methamphetamine use, that housing piece becomes that much more important because our target group has shifted ever so slightly as a consequence of that. I won't go over this for a long time, but you can see that meth-involved clients really started to spike around 2016. As I say, around 2019, that number went down. We had a little bit of shift towards opioids. Don't know why it didn't really catch on in Winnipeg. So fortunate that it did not. But now methamphetamine would probably be, my guess is probably 80% of our participants right now. Proof that it works. We always like to brag about this. At the time, we had 94 clients that were graduated. Only 32% actually made it through the program. Interesting number, I think. 10.6% recidivism rate. And of course, your numbers generally across the country are quite different, but I can tell you that in Manitoba, 67% of individuals who are incarcerated provincially, which means that they've received 2 years less a day or less. 67% of those individuals were reincarcerated within a 2-year period. And the number for the federal incarceration rate was pretty similar. Probation was 28%. So a significant decline from the recidivism rate. From the justice perspective, we of course look at that as being a very, very successful program. And that number is actually lower now. Now, just so you know, our numbers are actually a little bit smaller right now. We are trying to move those numbers up. At one point, we had 40 participants. Right now, we're down to 22 participants. In Western Manitoba, it's only 8 participants. So it's a very small number that we're dealing with here. And it's a challenge for us because in Winnipeg, at least, our waiting list is 3 times that number. So I think that's likely true for many of you throughout the jurisdictions that you're from. But Drug Treatment Court continues to be a massive success here in Manitoba. And we've been very, very pleased to be part of that, of the Drug Treatment Court phenomenon. Moving forward, I'm going to just tell you that sort of the 3 pieces that we've learned from Drug Treatment Court that we think are so important. I'm going to tell you a little bit about our challenges going forward. And I hope in doing so, you can understand that we are grappling with many of the same issues in Manitoba that you are. And that we recognize that in order to be successful, to deal with the individuals in a manner that's fair and consistent, we have to be transformative in our thinking from a justice perspective. And we are absolutely committed to that. So let me start by saying that the 3 principles that we've always looked at, the 3 sort of traits that we've looked at for Drug Treatment Court are as follows. Number 1, we expect clients to buy in. And you say, that sounds bad, and that sounds like a lot of things. That's true. But I always say you don't wash a rental car, right? So anybody out there right now, if anyone's ever rented a car and washed it, you put up your hand for me, please. I've never washed a rental car. And the truth of the matter is we want people to own their recovery. We want people to understand that the program can work for them and that the people who are involved in the program care about them and want to ensure that they're being successful. Second thing that we always talk about is this. We know when someone's going to graduate. In fact, we used to be able to call it, and that was this. When a participant invests as much in themselves as we're investing in them, we know they're going to be successful. And that's that shift to going from being a passive participant to being an active participant in your recovery. I'm certain that's a universal truth. And the third thing that we always talk about in Manitoba, at least, is we call it the rung principle. we get people from all rungs of the socioeconomic ladder. We've had homeless people. We talked to you a little bit about that. We've had multimillionaires who have been fallen down a path of addiction. And what our position is always the same, which is wherever you come to us on that rung, from a social perspective, from an economic perspective, whatever that may be, we want you to be one rung higher. We want you to show us that you are taking the steps towards bettering your life, and that we can work with you for that goal. So those are the three sort of general things that we often think about. Moving forward in Manitoba, I can tell you this, I'm very, very happy to be a part of the Department of Justice, where we are committed to drug treatment courts. We're actually looking at expansion of the drug treatment court program. We have 2 now in our province, and we're looking at 2 more. One actually is more likely to be a wellness court. We're looking at that in northern Manitoba, where there's a significant Indigenous population. We also have a mental health court here in the city of Winnipeg, which again remains very small. Right now it has 14 active participants. And we're also looking at a number of other options with respect to community justice options. Now, I see that my time is almost up, but I will tell you that, at least from Manitoba's perspective, our focus on reconciliation, I can tell you, has been very, very well supported at the political level, and continues to be very, very strongly supported among all the departments. So working from an interdepartmental perspective, we're looking beyond our justice model, looking to partner with families and health agencies in our province, and working very, very hard to find other ways to deliver meaningful treatment to individuals, especially those in remote communities. And I know that one of the things on your agenda today will be Indigenous courts. We are looking at some Indigenous courtrooms, but more importantly, in Manitoba, we're looking at systemic change that will address reconciliation for all individuals and all Manitobans. And as we do that going forward, what we find is that in remote communities, what's very, very important is for us to be able to find supports from a community justice perspective to ensure that we can support elders and community needs, especially in smaller centers and smaller facilities, and continue to work together to achieve more steps towards reconciliation. Without question, we have a long way to go. And in a province where almost a quarter of our population are Indigenous, it's clear that our focus needs to be on healing. As much as from a justice perspective, we emphasize community safety and the importance of community safety and individuals feeling safe in their community, we have also embraced as one of our tenets here in Manitoba that healthy community and healed communities are an important part. And so as we've gone through the last summer, we've dealt with the discovery of unmarked graves and the terrible tragedies that were part of the residential school legacy. We have continued in Manitoba to commit to a justice program that is transformative, that is focused on treatment, and is focused on healed communities. So many of the lessons that we've learned from drug treatment court, from mental health court, are going to be applied more broadly in the justice system. We are working very hard with our what we call in Manitoba the rights holder organizations, which includes the Manitoba Métis Federation, as well as 3 significant Indigenous political groups, and working with them to ensure that the delivery of justice is done in a manner that's consistent and appropriate for the cultural needs and the social needs of all of our population. So I see that I'm out of time. I'd like to take a special moment to thank Justice Barnes and the members of the committee for inviting us. It's my pleasure to appear on behalf of the province of Manitoba, as well as the many, many members of the Canadian Association of Drug Treatment Court Professionals. And I do hope that you'll share with us our goal of moving forward to a justice system that understands that many of the solutions aren't found in the justice system. So thank you to all of you for your work, for your continued involvement, and of course, I can tell you from my own experience, for your passion and dedication to the cause. Thank you very much.
Thank you, Attorney Akerstream. We do actually have one question in the Q&A box, and I'll pose that question to you. The question is, have you ever had issues attracting women into your program, with childcare often being cited as a challenge?
Great question. We haven't had a challenge with that. We've actually worked very closely with Child and Family Services in Manitoba. And we've actually, I'm very proud to tell you that we've had 7 clean babies born in the program, which is a great thing. And we've had a number of successful graduates. We're pretty close to 50-50 right now for female participation. And I can tell you that we invariably work with Child and Family Services to reunite families in Manitoba. In fact, it's one of our priorities here.
That's a pretty high percentage. Thank you very much for your time and for your keynote address. We're going to keep on going here. I'm not going to take a break, and we're going to jump right into the next session. The next session is timely and high quality and appropriate treatment. It's my great pleasure to introduce Judy Burns, who's the Executive Director of the Regina Drug Treatment Court and spent her early career managing detox and residential addictions treatment programs. In 2005, she worked on the proposal for the Regina Drug Treatment Court. And in 2009, she joined the court as the manager. And I'm happy to also report that the Regina Court also recently celebrated their 100th drug court graduate. So I'm going to turn over the floor to Ms. Burns and to introduce your panel.
Thank you very much, Dennis. And more research. You're a good researcher.
Have to take a look.
This morning, we have a great panel for you. I'm going to introduce them, and then they're going to go through their presentations. We'll take Q&A at the end. So please post in the chat, and I'll get those together for the panel. So we have today Kemi Jacobs is the Executive Director of the Delta Family Resource Center. She has over 20 years of community involvement, having been a leader in the public and non-government sectors. She will be speaking about the new culturally relevant programming Delta Family and Partners have created to help youth and families develop strong and positive racial identities. Along with her, her co-presenter will be Holly Lubert. She is Crown Counsel at Justice Centers. She has had over a decade of appellate prosecutorial experience and has appeared at every level of court in Ontario and the Supreme Court of Canada, with regular appearances at the Court of Appeal for Ontario. She has significant experience working with collaborative court models, previously acting as the Deputy Director of Inmate Appeals at the Crown Law Office Criminal. Most recently, she has been working with Dana Aaron, Executive Director of Justice Centers across the 4 Justice Center sites at the Downtown East, Toronto Northwest, London, and Kenora pilots. Following those ladies, we will have Jennifer Lysay. Jennifer has been working in the field of addictions and mental health for the past 18 years. She graduated with an honors BA from the University of Toronto in criminal psychology, history, and music history. She then pursued the postgraduate program in Durham College in addictions and mental health. The 18-month program included a 4-month practicum, which she completed at Pinewood Center of Lakewood Health in Oshawa, Ontario. She was hired after her practicum by the agency, first in their women's residential program and then in their community treatment outpatient program. Ms. Lysay also assisted in the development of Pinewood's alcohol and drug awareness program for the direct accountability program in alcohol and drug awareness. The direct accountability program in partnership with the Ministry of the Attorney General. Ms. Lysay joined the Durham Drug Treatment Court and Mental Health Court in 2005 and continues to work as one of the treatment providers in the program today, as well as continues to work in the community treatment outpatient program. Ms. Lysay became a registered psychotherapist in 2017 through the College of Registered Psychotherapists in Ontario. We will then listen to Nicole Hermanson. Nicole has had a 20-year career with the BC Corrections Branch. During this time, she's worked in various integrated multidisciplinary settings, which aim to assess individuals with complex mental health and addiction needs. Nicole has been involved with Drug Treatment Court of Vancouver since 2009 and has a passion for working within therapeutic problem-solving treatment court processes. Our final speaker will be Aspasia Papatheodoro. She is a lawyer with the Legal Aid Ontario. She's a graduate of the University of Toronto and Queen's University and was admitted to the Ontario Bar in 2007. Since 2008, she has worked as criminal duty counsel at Old City Hall, representing clients in the Toronto Drug Treatment Court, the Mental Health Court, and the Indigenous Persons Court. She has participated as a speaker both nationally and internationally on the topic of drug treatment courts. So we shall turn it over to Kemi and Holly.
Thank you.
All right, I guess, should I get started, Kemi?
Yes, yeah, please do, yeah.
Okay, fantastic. Okay, I'd just like to start by thanking the organizers very much for inviting us to speak. I'm here to give a little bit of information about Ontario's new justice centers, and specifically the Toronto Northwest Justice Center, really to help give you guys a little bit of context to better understand the really innovative and meaningful work that Delta Family Resource Center is doing in collaboration with MAG's Toronto Northwest Justice Center to support youth, and really specifically to support Black youth who are in conflict with the criminal justice system as part of my pilot. And I'm aware that my colleagues, Mike Brooks and Miriam Henry, who's actually the Toronto Northwest Crown lead, spoke to yesterday. And Miriam would be here today, but she's actually in court running this today right now as we speak. So you're gonna have to put up with me for the next 5 minutes. But we've collaborated, so we hope we're gonna give you some new information. Can I get the next slide, Cameron?
Yep.
Great. So before we sort of spotlight the Toronto Northwest Justice Center, I just wanted to give you a little bit of context about what our new justice centers are, because to understand the unique role that Delta Family Resources Centers programming is playing, you need to know a bit about what we're doing. So what are justice centers and what are they about? At its core, it's about innovating the way we deliver justice services from the inside out. As you heard, I'm a career prosecutor, and we're sort of the ones who are involved in really trying to innovate the way that we do our jobs. And it's about creating a community court model. We know the community courts have been cropping up internationally. And what are they? It's really a local neighborhood focused court that applies a problem solving approach to local crime and safety. Is it a new diversion court? No, it's not. Is it about replacing any of our existing diversion courts? No, it's not. It's about trying to take accused who are not eligible for diversion or for any of our existing specialized courts and finding a way to do justice better for those people. So really, for example, in the Toronto Northwest, it specifically includes and incorporates accused who choose to plead not guilty. It will in other courts, and as our pilots expand, choose to include people who will be going to jail. So it's about doing things a little bit differently. Can I get the next slide, Kelly?
There you go.
Thank you. Okay, so what are we doing in Ontario? We know we've got community courts internationally. What is Ontario doing? In Ontario, we are creating spaces that co-locate courtrooms and justice services with front-end supports like primary health care, mental health supports, with prevention services like employment and skills training, and with community reintegration supports like peer counseling. So it's one-stop shopping, all under one roof. And how are we doing this in Ontario? In Ontario, we've decided to go into community and listen. Or in the case of the Toronto Northwest, we've decided to not ask people questions we know they've been asked before, but to do a deep dive into the socio-legal research that exists to determine what kind of local justice solutions will actually best meet the local need of the people who are there on the ground and who know what's happening. And so where have we done this? In Ontario, just to give you an idea of the breadth of the program, we've done this in 4 places. We've done this in the Toronto Downtown East. In the Toronto Downtown East, we have a hybrid health and justice center. The goal there is to address chronic recidivists who are living sort of at the intersection of homelessness, underhousing, poverty, mental health, and addictions difficulty. And it's really focused on healthcare. We're doing this in London, where we found a high proportion of NEET youth aged 18 to 24 who are otherwise not in education, training, or employment. And that focus is really on addressing mental health, addictions, and training and peer supports. We're also planning to launch in Kenora. Our pilot in Kenora is going to focus on the problem of Indigenous overrepresentation. It's going to include parallel criminal and Indigenous processes. But we're here specifically to talk about the Toronto Northwest. Kemi, can I grab the next slide? Okay, thank you. The Toronto Northwest. So what does this slide tell us? It tells us in the Toronto Northwest, we are covering a lot of territory. The purpose of this is to show our catchment area for the cases that we're pulling from. We're pulling matters from TPS divisions 12, 22, 23, 31, 32, and 33. So a lot of cases. Our pilot is also going to be aimed at youth in particular. And at the Toronto Northwest Justice Center, the purpose of the pilot, as was developed by and for the community that it's serving, was to be a response to community violence and gun crime that's aimed at addressing the intersection of poverty and criminal justice on youth, and particularly racialized youth aged 12 to 17, by providing culturally relevant programming. And that's one of the reasons, of course, why we partnered with Delta Family. The pilot offers targeted multi-sector community supports and programming designed to wrap around youth and meet underlying need to break the cycle of offending. And in terms of, to give you a little bit idea of, would I be able to get the slide just before this, Kemi? The
Okay.
robbery pilot, if that's okay?
There you go.
Oh, fabulous. Okay, and just to give you, I see I'm cognizant of my time. I'm running a little bit out of time, but
That's
just
good.
one of the pilots that we're running in the Toronto Northwest is our robbery pilot. And you sort of say, you know, why robbery? And we know there's a lot of robbery in the Toronto Northwest. We know that at 2201 Finch, we know 1 in every 5 youth cases is a robbery case. That's a very high percentage. We know that it's a gateway offense. We know it can be an indicator of future criminal involvement. We know youth tend to commit it in groups. And we also know that the victims of these robberies also tend to be youth. So at the Toronto Northwest, we're trying to work differently with victim services so that we can offer services to those victims, because we know that, you know, we see in this offense the cycle of victimization and offending. Somebody is a victim one day, they're an offender the next, and a witness the next. So we want to be able to have that flexibility to offer services to sort of break that cycle of offending, you know, when at this point, when people are still young. We're also trying to work with families differently. So we have the flexibility at the Toronto Northwest Justice Centre that if we see a sibling falling into some of the similar patterns that an older sibling may be falling to, we have the flexibility to direct some programming there. What kind of program are we talking about? I'm going to address that really quickly. First off, one of the key features of our pilot is that when an accused comes into the Justice Centre, which is usually within 21 days of arrest, so very quick, right? We're not waiting for the Jordan timelines to run out. We're addressing things quite quickly. We'll develop an individualized plan. Accused will work with a community service navigator to determine which services and supports are required and put them into place. And we have some wonderful services and supports. We have a dedicated child and forensic psychiatrist who is right there available to provide help when needed. We also have an education advocate, a lawyer from Justice for Children and Youth who is tasked with reconnecting youth with school and helping identify and secure future educational pathways for them. Another feature is judicial case management, so that we know our matters will return to the Justice Centre at flexible intervals for judicial monitoring. And I want to keep in mind, this isn't just any old check-in, right? This is a check-in with a judge of the Ontario Court of Justice. So it's a big check-in. It's a significant feature. Our other feature is to have tailored programming. And specifically culturally relevant tailored programming for the individuals who come into the Justice Centre. And this is, I think, where Delta Family Resource Centres comes in.
We're going to speak about some of the
first appearance. I'll give you very, very quick. I'm very cognizant of my time. For our first appearance pilot, it's another feature. And just to give you some idea, for the first appearance pilot, all of the out of custody youth cases from those catchment areas will come into the Justice Centre for their first appearance. They may return to 2201 Finch, but the purpose is to bring them into the Justice Centre so that they can have the option, if they want to continue on in the Justice Centre. And even if they don't, they have the option to access all of the services that are available in our mainstream robbery pilot, should they wish to.
Okay, thank you very much, Harley. You did really well with the time. So we've been
I tried.
You did really well. So yeah, okay, good. So I'll tell you a bit about Delta Family Resource Centre and specifically the supports that we provide. If I want you to take away 3 things from my presentation, and I think the context was that Harley provided was really important in terms of the partnership between MAG and Delta Family, and not just Delta Family, but other community partners. So the 3 things I want you to take away are 1, the whole person, 2, culturally relevant services, and 3, the community. So Delta Family provides wraparound culturally appropriate services and programs for Black communities. We have been in Northwest Toronto for more than 40 years. Our strategic priorities, and I'm giving you all of this because it fits within a context: reducing poverty and community capacity building, enhancing family wellness and mental health, prioritizing programs focused on Black communities, also enhancing services for families, youth, and seniors. So we have 2 youth justice programs where we work with the entire judicial system. So Meridane works with youth from 12 to 17, and we're hoping to expand that, but it provides culturally appropriate wraparound services to Black and racialized youth and their families. That piece is really important because we treat the whole person. A young person who comes in contact with the justice system, it doesn't just happen to her or him, it's the entire family that is traumatized. And we really want to make sure that our motif almost, so to speak, is making sure that contact with the justice system does not wreck the lives of Black youth and their families. It connects youth and their families to external referrals and other supports. We have youth justice workers, and within Delta Family, we also have counselors. Another program, which is federally funded, is the Ounce of Prevention, or PEMPANSI. We have 8 youth justice and reintegration workers, 2 counselors, wraparound supports, and peer supports. And basically, they support the youth and the entire family. We speak about culturally relevant services, and it's become almost like a password. What does that mean? For us at Delta Family and our partners, it means seeing people who look like you. A lot of the young people who go through the justice system are Black, and they don't see many other Black people. It's changing, except other people who are charged. So when they come into an organization like Delta Family, they see people who look like them. The space reflects them. Counselors who get it. Nothing is worse than, and we've heard this from clients, having to repeat themselves and tell their story to people who really just kind of look at them in shock. So it's really important to feel that the staff and the youth justice workers who you're working with actually get it. Music is a big part of youth culture. So using music as an engagement tool. The names of our programs, Memere Dane is an Adinkra symbol, which means time changes, because we hope that things will change for young people as they go through our programs. Pempansi is it's an word talking about unity in strength, being ready. So again, we really affirm Black African identity. Our events are also a big piece of the work that we do. And this is a resource book that we developed for youth workers in the justice system. We look at some of the work that the youth justice team does with young people who are charged around identity. Then goes a SABA, which are principles which govern Black community. Self-advocacy and system navigation. Those are some of the types of things that we do with young people and their families. Youth justice services, these are some of the things that we do. The services we provide, tailored, culturally relevant, customized approaches to supporting families. Justice navigation, accessible, user-friendly short videos. With MAG, we've developed a series of 5 short videos, which really just say your first court appearance, words you'll hear in court and what they mean, tips on choosing a lawyer, those types of things. We also have a series of Black focus programs. So it's not just the one program, there are other things that the young person who is in trouble with the law can also connect with, and their families. So we have programs like Motivated Mamas, Black Dads, home daycare training, etc., etc. Our counseling department, again, it provides culturally appropriate services and supports for families. And it also looks at non-traditional ways of healing as well. Yeah. Support, so we provide a food security, one-on-one counseling, job search and preparation, and again, partnership is really important. We can't do it on our own. No one agency has everything. So it's really important to work with partners. We have a school and family advocate program where workers in schools advocate with Black families and students when they face anti-Black racism in the school system. So we're looking at a real wraparound service. We're looking at a holistic approach. And this is where a young person who is feeling very isolated, feeling very marginalized, will begin to connect with community and see that there are supports for them. The SNAP program works with young people who are having behavioral problems and their families again, and helps them to make their problems smaller. That's one of the things that they speak about. We have programs for seniors, storytelling, networking, Zumba. We have a sewing hub, a sewing repair hub, where people can get things repaired and learn how to sew. Maybe pick up a little side gig. So we're looking at the whole person in different ways. With COVID, we've had to do a lot, and I'm really aware of the time, and very shortly. With COVID, we also look at supporting families who have been affected by COVID, lost jobs, etc., needing food. And so overall, the services that we provide with our partners and working with MAG ensure that Black youth who are in conflict with the law have a soft place to land. I think that's the end of my presentation. I'll stop sharing my screen. Yeah. So I'm sure there may be questions, but I know I have three other colleagues waiting to tell you about their services. So I'll end here. Thank you. I think the next speaker was it Jen?
Yes, it is. Hi. Hello, everyone. Thank you for having me today. So today, what I would like to speak about is kind of a combination of the services that are offered through my primary workplace, which is Pinewood Center, which is through the mental health program of Lakeridge Health. So I'll start by sharing my screen. So Pinewood Center has had a very strong collaboration over the years when it comes to, sorry about that, dealing with the justice system and assisting clients. And that has been something that has really been focused through our agency. Okay. Sorry, it's not sharing, it's not switching sides. There we go. So some of the programs that we do offer are the Youth Diversion Program, which it is a program that allows youth to, instead of receiving charges, they will be allowed to access treatment through us. And whatever their treatment program is, they will come up with it with a counselor. And it's a partnership with the Durham Region Police, John Howard Society, Eastview Boys and Girls Club, and Pinewood Center. So, and it's to divert youth by getting them into an appropriate community-based service so that, you know, because sometimes it's about getting life skills or learning new information with the hope that it will help them to decide to make positive changes. We no longer are running this at Pinewood Center, but we were, and it was a direct accountability. And again, similar kind of opportunity for individuals who have minor charges and would benefit from some sort of treatment. Now, it is offered through the John Howard Society in our area, but we would offer the alcohol and drug awareness program. So when a substance was involved in their charge, they would be offered to come to our agency and do this program, and then they would go back to court and their matter would be dealt with. We also offer what we call the Pathways program, which is a pre-contemplative type of program for individuals that, you know, don't really know or don't really feel that they might have a problem or need more education around that. We really find that majority of our clients are fit with the probation or have been recently charged, or those individuals really fit in our Pathways program. We offer it to any client that comes into our agency, but I would say that a huge majority of them are our probation or clients that are involved with the legal system. And what it does is it helps client to get a different perspective on all life areas, not just their substance use, but basically looking at how their substance use impacts the issues that they're dealing with, right? We have the mental health support unit, which also helps individuals who have been charged have substance use related, but it's more results of their mental health. So we have a specific worker that will work with them to help get the treatment that they need. Concurrent disorders court diversion program, similar kind of situation where individuals will you know, get the treatment. They might have to meet with a psychiatrist. They meet with another agency that has now part of Lakeridge Health, Durham Mental Health Services. So together with Pinewood Center and Durham Mental Health, they come up with a treatment plan for the individual to get the treatment that they need and also deal with their charges. But in this way, it's not just, if you want to say, jail time or a fine or anything. They're actually getting, sometimes it's life skills. The individual doesn't have the life skills to deal with with life, and they're able to pick that up through these programs. And finally is the Durham Drug Treatment and Mental Health Court Program, which I am one of the treatment providers for. So, for clients who are, have extensive nonviolent criminal charges related to their substance use, and they have mental health issues. So we look at it from the perspective of, we will address both. Instead of custody, we offer a type of therapy or treatment type program for these individuals. And we work as a team. In our team is many different agencies, with that, we have the local judiciary, we have the Durham Crown's Office, the PPSC, Pinewood Center, Durham Mental Health, Durham Regional Police Service, the bail program, Salvation Army, probation if required. And together we work as a team to help this individual, because again, it really is about life skills and just learning the basics. So rather than putting them in custody and repeating the scenario over and over and over again, the opportunity is to hopefully show them something different. And we've had a lot of successes in our program, many graduations, and with clients that what it does is it instills hope. Many clients come into the program and that's something that they don't have. Whether it be life or trauma or various things that has happened as a result, they come to our program in a place where they feel like resigned. And as a result, they're unable to see anything else. But I feel through drug treatment court, we're able to show them that. So, simple things that others might think, oh, some may take for granted, but to complete, we assist them with stable housing, no use for 3 months. We help to stabilize their mental health and help to make lifestyle choices that support their recovery. And I think that is the most important thing that we have to recognize is it's not just once they finish the program, okay, they're done. They are able to maintain and support those changes on their own. Okay. So other programs that we can refer to while individuals are in our program are the withdrawal management, the intensive outreach program, so individual counselors that work in the community for clients that are homeless or transient. We have an addictions day program, mental health day program. We can refer to a psychiatrist if necessary. We have our RAM clinics, which have been really key in assisting us with stabilizing clients, whether it be opioid replacement therapy or through anti-craving medications, or even just getting a person stable on their medications. They've been really helpful in doing that with us. Our early psychosis intervention program, individuals that have experienced first episode psychosis, there's a team that will work with them. Positive care clinic for any health issues that clients might be dealing with. A referral to residential treatment for women. So we have one in-house, but we can also refer out to one for men. A supportive housing program and smoking cessation, which is one thing that clients really say, that's something that I would like to work on. So we do that. What I'd like to note is, as I listen to everyone's presentation and my co-presenters, that the key, I think, what ties the justice and treatment together is the use of motivational interviewing. So you see that techniques rest on the findings in clinical experience and research that simply show that clients who believe they can change do so. And those who are told that they are not expected to improve indeed do not. And I think that is key to all of these programs, or in this collaboration that's happening with justice and treatment, is that there is the foundation of motivational interviewing, which is so important, because what it does is it helps the individual to create change. So it provides the individual with the opportunity to take control, because a lot of times they don't have control. So what you're doing is providing them choice. And one thing I like to say is, even though, they might present to us initially and say, I don't want to do this program, I'm being forced to do this program. Often I say, well, what is your options if you don't do the program? And they'll say, well, okay, well, I'll go to jail or I'll get a fine. So in the end, you're making a choice. You're making a choice to not go to jail or not pay a fine. You're making a choice to do this program instead. And rephrasing it to them from that perspective gets them to see it in a different light and help them to realize that it's not the probation, it's not the courts or anything that's in control, it's they're in control. And I think that is the key with all of these programs. As I listened to my previous co-presenters program, again, it's all instilling choice and options and just empowering clients. And it's done through the justice programs as well as in the treatment programs. Individuals' autonomy is respected. The collaboration helps to build rapport, brings on trust in the relationships with the clients, right? Because working in the courts and seeing sometimes as being a treatment provider in drug treatment court, I'm seen as an extension of the court. You're going to tell the judge, I'm going to get in trouble. So a lot of that is, as well as with the judge, is assisting the client to see that we're on your side. And sometimes it takes a long time to build up that trust because every time they've been in court, it hasn't been a supportive experience. So focusing on the strengths and instilling hope for the clients and showing them that even small change, hey, it's been one day and you haven't used, but for the past 3 months, you've used every day, that's a success. Because the justice system is collaborating and doing these partnerships, it really is helping to create those change. Before I finish, I'd like to share a case example of an individual that we worked with, and very entrenched with the drug culture and behaviors, and had been doing that for, it must have been about 30 years or so, multiple charges, repeat offenses, very engaged, multiple overdoses, and was estranged from his family. And finally, and often at times throughout those years would seek treatment, but the last charge was an opportunity to really make some changes and was entered into our program. He really struggled with life skills because he had been using for such a long time, simple things of how to deal with sadness, how to deal with happiness, how to deal with anger, stress. All those things were a challenge to him, and he didn't know because his first go-to was using a substance. And over a period of several months, first off, again, we worked really hard as a team to help him to build up the trust. And then he was able to come to a place where this individual was using fentanyl daily, and he was able to come to a place where he stopped using. There was sporadic relapses, but he was able to come to a place where he was able to rebuild the relationship with his family, which was huge for him and huge for his family. Unfortunately, he relapsed and he did overdose and he passed away, which was definitely a huge shock to the team. And it really, it set into place how dangerous the use of the opioids and fentanyl is and how easily people can overdose. But I think the bright light out of that was the family reaching out to the team and saying to us, you know what? We thank you because we actually got a period of time to be with our son, the person we knew, because we hadn't seen that person for so long. So it's that kind of stuff that working together not only helps to heal the person, but also helps to heal the family. And I think to close off, I'll just say, these are two articles that I've referenced in this presentation. really good information on working with motivational interviewing in the criminal justice system, right? Because it's not just a change for the clients, but it's also a change for the providers. Huge. I mean, the change for the justice system, change for the judge, the crown, all of that, change for the treatment providers, right? We wouldn't necessarily say, oh yes, we want our client to go to jail, but we have to recognize that that might be an option. And I think I can say for our program in Durham, what I do note is that we respect each other's roles. So we respect the fact that there's certain things that we can do and there's certain things that we can't do, certain things that we can say and certain things we cannot say. And we respect the policies of each other's agencies, which helps to really create a positive environment, an atmosphere, so that we can provide treatment and focus on the treatment goals of working with the client. So in turn, the motivational interviewing as well comes into how we operate as a team and the respect and the choice that we offer each other's. Thank you for allowing me to present today. And I believe it's Aspasia. No, it's Nicole next, sorry.
I think it's my turn. I am hopeful everyone can see and hear me okay. And I will start with sharing my screen. What I can say is I'm here joining from Vancouver, British Columbia, and I will say it is the crack of dawn here. I'm facing east, so as I do this presentation, maybe you will start to see the sunrise. I'm sitting here in the dark. So I'm happy to be here, and thank you for inviting me. And let's get the show on the road here. So I'm the local manager for the Drug Treatment Court of Vancouver. We are the only drug treatment court in British Columbia. We're located in Vancouver, BC, and we're literally at the epicenter of the opioid crisis. And so we have two locations, essentially. As it says here on the slide, we have the courthouse, which is located at 222 Main Street, and then we have our treatment and resource center. So what exactly is Drug Treatment Court of Vancouver? It's essentially similar to many of the other drug courts across the province and across the country. It's a specialized court offering coordinated integrated support for adults struggling with addiction and who have been charged with a criminal offense. It's a problem-solving court strategy in the criminal justice system, and it offers an opportunity for individuals to choose treatment over custodial dispositions and or lengthy community supervision. All of our team is trained in trauma-informed practice, and also we employ a harm reduction model. And now with the harm reduction model, the ultimate goal is abstinence, but we understand that harm reduction is on a continuum, and everyone's place within that continuum will vary. The ultimate goal also is to improve life skills, housing, employment, and education, and the overall quality of life for our participants. So what is the team? Essentially, it's a designated judge, a designated Crown Counsel, designated Defense Counsel, and an integrated team. Now, the integrated team at the Treatment and Resource Center, we are all located together. So I think this is one of the things that makes our drug court unique, is that we're under one roof in terms of the integrated treatment center team. And with that team, we have our correction staff. The local health authority is contracted, so Vancouver Coastal Health, and we also have the Ministry of Social Development. So what does that mean specifically? So we have a local manager and we have 2 probation officers. Within the Vancouver Coastal Health Authority, we have a clinical supervisor, a physician, a nurse, trained addictions counselors, a peer support worker, program assistant, and a psychologist. We also have the Ministry of Social Development and Social Innovation. So we're able to provide wraparound care for the individuals that come into our program. There's the team. And I'd be remiss if I didn't add this photo. We actually won an award that day, so we're pretty happy. We won a provincial award in excellence for spirit, in the spirit category, for our work with Indigenous participants and with our Indigenous cultural programming. So I had to add that slide. Okay, so what is the treatment program? It's roughly a 14-month program, and it can take longer. We can have clients in the program for up to 2 years, 2.5 years. It's really based on their progress in the program. It's a phased group-based program with individual support and to complete treatment. So there's group programming as well as the individual support and individual counseling. The program involves a holistic approach to treating addictions as well as the criminogenic thought processes. So treatment modalities that are used, CBD, crisis intervention. We have a unique court where sanctions and rewards are offered. Legal supervision, so there's regular court appearances for the participant, depending on where they are in the program. They can appear anywhere from 2 times a week to once per month. So how they are progressing through the program will determine their court appearances. There's urine screening, individual counseling, pharmacological treatment. We do have a methadone doctor, and we are able to prescribe and monitor any kind of withdrawal management and OAT therapy. We also do referrals to housing and vocational services. So who comes into the drug treatment court program? So anybody who is addicted to the CDSA substances, so any illicit substances, cocaine, opiates, methamphetamine. We are seeing in Vancouver a very high percentage of individuals that are addicted to opioids, given the opioid crisis. So we also, so who can we not accept? We don't take any individuals that have a high risk for violence, any domestic violence, sex offenders, or residential B&E. The reason for that is we don't provide the specific programming for those types of offenders. That can be done in other community supervision offices. No gang or criminal association. No one on a conditional sentence order, and charges elsewhere that interfere with participation in drug treatment court. Now, having said that, we have opened up our borders and we are able to take anyone in the province if they are willing to relocate. COVID has really assisted us in being able to do virtual programming as well as virtual screening. So we are taking people from all around the province, provided they are willing to relocate. Another individual that would be ineligible is someone who's subject to removal from Canada. So it's best if they are a citizen, a Canadian citizen, or a permanent resident. And also if there's a language barrier. Now, having said that, we also do accept participants that have language barriers, and we can refer them to English classes or tutorials. These are some photos at our Treatment and Resource Center. We do what we can to make it seem warm and welcoming and inclusive and non-institutional. So how is our drug court effective? Essentially, it addresses their criminal addictive behaviors with appropriate sanctions and intervention treatment. It's a coordinated treatment and offender supervision, which works better together and as an integrated unit. So research has shown that drug courts significantly improve substance abuse treatment outcomes, substantially reduce crime, and produce greater cost benefit than many other justice strategies. So there has been some research, and I'll touch upon that a little bit later in the presentation. With regards to the integration piece, is very essential and really harmonizing justice and health. So through the program, there's a number of things that work and a number of things that are done. Group counseling, so like I had mentioned before, it's a phase-based program. There's 4 phases, and it is group counseling and it is group therapy that is really at the heart of this program. Now, having said that, there's individual counseling and case management. We pair a probation officer with a counselor, and they're called a care team. So that care team will have a caseload and will be able to address the individual in a holistic way. And with culturally relevant programming and relevant material, they will employ motivational interviewing and really wrap around care and treatment programming for the individual. And as mentioned before, we have a doctor as well as a nurse. There's a little idea of their setup. Many of the participants that come into the program have been entrenched, street entrenched, and really have not seen a medical professional in a number of years. So this could be their first opportunity to get just a very basic checkup and assessment. So this is a very good opportunity to address their healthcare needs. Urine drug screening is an integral part of our programming. The clients are screened, and with urine screened, depending on where they are in the program, how often, no less than 1 time per week, but they could be screened. It's a randomized process. They could be screened multiple times a week, but no less than once per week. And we are looking at what substances they're using. And we ask for a disclosure prior to them providing their urine screen. The nurse will ask them for a disclosure of what they have used. A participant is never sanctioned for use, but what is important around their use is their honesty. So they fill out a form and they will be asked what substances they've used in the last week. And we're looking for them to be honest about that. Now, if they are dishonest, then they could face speaking to the judge about that and a sanction in court. However, having said that, there is never a sanction for use. We expect, especially when participants come into the program, we expect that they are using, and we just need to know what they're using so we can provide adequate treatment programming for them. So what are some of the other things that the team does for community reintegration? We do outreach support, home visits, community special events and outings, one-to-one outreach for appointments, referral to community services, and follow-up support. We have ongoing relationships with a number of recovery houses in the community. So the team is able to place participants in recovery houses quite quickly and right from custody. So we'll do treatment planning as soon as somebody comes into the program. If they come in from custody, then we're able to place them in a recovery house. We transport them to the recovery house. We bring them to the services that's required. And we also provide transportation, bus tickets when they come to the treatment center, and snacks and lunches. So it's a really therapeutic, warm place for them to be. Another thing that should be mentioned is we utilize various services in the community. Withdrawal management. We have a couple of withdrawal management sites in the downtown Vancouver area. And we also use the Rapid Access Clinic outside of in our St. Paul's Hospital. And so they can access OAT therapy quite quickly if need be. So it is important to mention that our court piece is designated crown, a designated judge, and a designated defense. We meet and do pre-court before court, and I believe other drug courts across the country run this way. We do pre-court prior to each individual's court appearance. We will do a meeting about the court list for the day, and it's a collaborative, integrated process. And it's really important to mention at this point that the participants really, their relationship with the judge is essential. 80% of participants generally believe that involvement of the drug court judge is critical to their success in the program. Now, Doug Marlowe did a study, and there have been a number of studies about this, and the relationship with the judge has actually said to be, and as research indicates, the strongest relationship that the participant will have. So it can impact, the relationship with the judge can impact the participant's behavior more than any other relationship in the program. And so the judge is very aware of this reality, and there's been some research around how long a judge should speak, and she really wants to get to know the participants, and she really spends the time and listens and gets to know them. And there's research around 3 minutes that the judge should be speaking to each participant about their life, circumstances, about how they're doing in their recovery. And so roughly 3 minutes, she tries to engage with the participant. Now, having said that, with COVID, we are virtually doing court, but we're hoping to move into more in-person court appearances as time goes on. So in order for a participant to graduate, now roughly 20% of our participants graduate the program, which is a really high statistic. For a participant to graduate, they have to complete all 4 phases of the program. They need to be abstinent from illicit substances for 3 consecutive months. So 3 months of negative urine screens, no new offenses within the past 6 months. They need to be having stable housing. And for the final 2 months of the program, they should be engaged in some sort of pro-social behavior, whether that be employment, schooling, or volunteer work. Now, unless they're medically excused and they are on PPMB, so they're on assistance, but otherwise we expect them to be in some sort of employment, schooling, or volunteer work. And I promised research. So here's a little slide on the research. Julian Summers he's from Simon Fraser University, has done a number of studies on drug treatment court and integrated therapeutic court models in general. But what he has found is that the Drug Treatment Court of Vancouver has reduced recidivism by 56% over a 2-year period, and overall criminal reoffending was lowered by 35%. And even though at least 50% of the participants had been considered to be severe risk to reoffend, so those high recidivism risk offenders has been reduced by 35%. That is huge when you look at the general prosecutorial system and community corrections. Drug treatment court certainly has a higher success rate than the other types of community programs. So I will just give a moment. This is some of the things that our graduates have said when they complete our program. I'll give you a moment to read these. This one, you know, it really touches me, and it just really exemplifies the physical and the medical illness and sadness with addiction. So I like to point out in this slide that when a client comes into the program speaking about the real change came for them, many of the clients, when we speak about motivation, many of the clients, when they come into the program, they may not be motivated to make that significant change in their life. They may not even think it's possible, and that's okay. They may just think they want to get out of custody, and that's all. They want to get out of jail, and that's okay. We bring them into the program, and we bring them into the fold of our treatment programming. And as they start to feel more empowered, they start to envision a new life for themselves, and they start to think that rehabilitation is possible, and they start to believe in themselves. So the motivation will shift over time. That was a female participant in 2016. So our drug treatment court we're hitting our 20-year anniversary this year. So we'll be in operation for 20 years, which is quite significant. And since the beginning, we've had over 1,000 clients have participated in the program. Nearly 300 participants have successfully completed the program. So that's a significant number. Research indicates a reduction in both drug reoffending rates and overall criminal reoffending for those individuals involved in our program. So one of the things I want to point out is the success that we have with our Indigenous participants. Research indicates that our drug treatment court in Vancouver has a high success rate with female Indigenous participants. And we really see that in the numbers, and we really see that in each day. We have a number of female Indigenous clients that make it all the way through to graduation and really make a huge change in their life. And part of that is due to the wraparound care that's provided, and it's also due to the culturally relevant programming that we offer for our Indigenous participants. So that concludes my presentation, and I think that we will be taking questions at the end. So I will end it here, and if there are any questions, we will address them at the end.
Okay, thanks, Nicole. I am going to be speaking next. I'm going to be speaking about the other part of the justice partnership. So we've heard from Holly on the MAG perspective about the community courts, and we've heard from treatment providers, but the other part of the justice treatment partnership would be defense counsel, who are often the first point of contact for clients who engage in these programs. And I'm going to be talking about some legal considerations that counsel need to have before the client comes into the program. And I've sort of separated my discussion into two parts. One is knowing the program and knowing your client. So before your client even comes into the program, it is important that you know about how the program is running. So there are different programs for treatment and restorative justice. The ones I'll be referring to are the ones that I work in, which is the Toronto Drug Treatment Court, the Mental Health Court, and the Aboriginal Persons Court. So it's very important prior to coming in that you understand the eligibility criteria of the program and fully understand them so that you can explain those to your client. I know in the Toronto Drug Treatment Court right now, we don't have a wait list, but sometimes there is a wait list. And so when you submit the application for your client, it may take a couple of weeks to get an answer, and then the client may be on a wait list. If you don't know all of the important eligibility criteria, you may be putting your client in a position where they're just sort of in limbo and waiting, and then only to find out that they are not eligible for the program. It's especially problematic if your client is in custody. So it's important that you know what the criteria are and what is expected of your client. If you're not someone who works in those programs regularly, it's important that you speak to someone who does. There's usually duty counsel who work in those programs, other defense counsel, the Crowns, or even the treatment provider who facilitates the program. It's either for drug treatment courts, the treatment providers, Aboriginal organizations in Toronto. It's Aboriginal Legal Services that works with our court. So it is very important that you know what is expected of the client so that you can actually advise your client properly. There are simple things that you may not have considered. For example, for some programs, you need to be out on release. You can't enter the program from custody. So that's an important thing to know if your client is in custody. Some programs require a guilty plea. Some programs only require that the client take responsibility. And some programs, like the mental health diversion program at Old City Hall, doesn't even require that. So it is very important that you understand the eligibility criteria and the basic parts of the program so that you can properly advise your client and speak to them about whether that's the program that they need to be in. Another part, it's very important to understand about treatment and restorative justice court programs, and one that everyone has discussed this morning, is the different role you often have as defense counsel or as counsel of any kind in the program. So as defense counsel, your job is to be a tireless advocate for your client. And you do that, and you still definitely do that in treatment and restorative justice courts, but those courts often work as a team. They're collaborative as opposed to adversarial. And so much of our system is adversarial that when you first come into these courts, it is a bit of a shock. And it's important to understand that your role is going to change slightly. So for example, in a drug treatment court, the common goal is reducing or preventing a client's further engagement in the criminal justice system by addressing their substance use, because that's what's brought them into conflict with the system. Everyone on the team is working toward that goal. So the judge, the Crown, defense counsel, in our court, we have a paralegal, we also have probation and court officers. It's not an adversarial system. We're all working towards that one shared goal. And when you work in the justice system, it often feels so adversarial, and it's a very different experience working in these courts, collaborating and working as a team with a shared goal, as opposed to your side and my side. So it is important that you understand you are going to be in a different role. You obviously still have professional responsibilities. You're going to be a tireless advocate for your client. There is confidentiality. There are professional responsibilities that you have, but those need to be balanced with the shared collaborative approach of treatment and restorative justice courts. Another important aspect to understand with respect to the program is what legal jeopardy your client is going to face. You need to know that so that you can properly inform your client prior to them entering into the program. Clients are often giving up certain rights so that they can benefit from the program, things like a right to a speedy trial, sometimes full disclosure. They may have charter breaches that that have occurred in their cases. In restorative justice and treatment courts, clients are often giving up those rights so that they get the benefit of the program. Most of the programs have a rule and waiver or an agreement form that sets those out. If it doesn't, though, you need to make sure that your client understands those things. It's also important to have a clear picture of the legal jeopardy your client is facing, because that may affect immigration or family court proceedings for your client. So at the outset, before they come in, this is something that you need to turn your mind to. For example, at Old City Hall, our drug treatment court requires a guilty plea and the client will get a criminal record. So that is going to factor into what you're going to discuss with your client before they enter into a program. Other drug treatment courts don't necessarily require one. I know that there are different streams in other courts. There might be withdrawals, but know in your program what is required. It's also very important to know what legal jeopardy your client is going to face if they don't complete the program. So right at the outset, I mean, our hope is always that the client is going to complete the program, but that's not always the case. They are very hard programs to get through for some people, so you need to know beforehand what jeopardy they're going to face. With our Aboriginal diversion program at Old City Hall, we don't withdraw the charges, it's a stay, because the charges are stayed up front and then the client attends a community council hearing with Aboriginal Legal Services. So you need to be able to describe the legal distinction to them. As well with mental health diversion programs, it's generally a withdrawal. Sometimes there's a peace bond. You need to know right off the bat what your client is looking at before they go into a program so that you can explain to them what their jeopardy is. It's also important to understand anything that may be required after the program is completed. So as I said, for mental health diversion, there might be a peace bond. There may also be probation. Our drug treatment court does have probation afterward, and we maintain a connection to the clients in that period after they graduate. We have a dedicated probation officer in the Toronto Drug Treatment Court, and she is the one who takes over all of the probations of the graduates, and they check in with us once a month as part of their probation. So on top of knowing the program, it's also very important that you know your client. As someone who spends a considerable amount of her time working in these courts, I know how important they are. I know the help they provide to people. I drank the Kool-Aid. I am someone who has prepared pitchers and is serving people the Kool-Aid. I know how important these programs are and the success that I've seen in my own clients, but I'm not naive. They're hard. They're not easy programs. So it's important for you to know where your client is on their journey. You need to have some idea of that because the structure of some of the programs, your client may just not be in a place to do the program based on the structure of the program. And then you run the risk of your client incurring more charges and finding themselves in a worse position legally. It's for this reason that some courts, like the Toronto Drug Treatment Court, only accept clients who are considered medium to high risk criminality. So it's usually clients who have a criminal record, who've been involved in the justice system for some time. I know other programs do accept clients with low risk criminality, but those programs also have generally a separate stream because there is an understanding and there is research that shows putting all of them together does make things worse often for the clients who are considered low risk criminality. So it is important for you to know where your client is in their journey. And some programs like the Toronto Drug Treatment Court do have a probationary period. So if your client is sort of on the line, they're not sure if they're fully ready to commit to recovery, if the program has a probation period, that is very helpful because oftentimes the client can just withdraw in that probationary period. Courts like the Drug Treatment Court, they're there for clients who, as I said, are ready to commit to recovery, but it is a complete change to their current life. And so they need to be ready to engage in that process. It's also, I know it sounds kind of obvious, but it's important to understand what issues your client is struggling with and to fully understand that. Is it substance use? Is it mental health? Is it concurrent disorders or a dual diagnosis? You need to know exactly what your client is struggling with so that you can ensure that the program that is best suited for them is addressing those issues. And if the issue is substance use, what substance are they using? Substances like crystal meth and fentanyl do prove to be more challenging for treatment courts. The period of stabilization is longer in the beginning. You may find that your client is incurring some charges at the beginning. I know when I started in the Toronto Drug Treatment Court, cocaine was the main issue, and then it had started to become crystal meth. And then in the last few years, it certainly has been, fentanyl and opioids. So we as a program work as a team and understand the changing nature of that, but you need to know what your client, what substance they're using, and understand that with certain substances, it may be that they're going to incur some charges in the beginning of the program during stabilization. It's also important to know, with respect to the program, do they have the capacity to deal with clients who have a dual diagnosis or are dealing with concurrent disorders? The Toronto Drug Treatment Court, we're extremely lucky. Our service provider is CAMH, so we definitely have all those resources in place. The treatment provider in the treatment court you work with may not have those resources as part of their organization, so it's very helpful early on to advise treatment providers in those courts about all of your clients' issues, be they either substance use or mental health diagnoses. That way they can put in place some supports for when your client comes in or look for supports. In the mental health court, we do have clients who are doing mental health diversion, but if the client also has substance use disorder, we do have a worker at Old City Hall who is a concurrent disorders worker, and he works with those clients. So it is very important so that you're not setting your client up to fail, so that all of the issues that need to be addressed are being addressed and the supports are being put in place for them. And you may have cases where a client starts in one court, but then another issue becomes a problem. So I had a client who was in the drug treatment court, and then his mental health issues became his primary issue of concern. And so in collaboration and with the consultation of the Crowns and the whole treatment team, this client was moved from the drug treatment court to the mental health court. He did mental health diversion and he completed it earlier in the pandemic. And so when you're working in this collaborative team approach, these are the sorts of creative solutions you can come up with to assist clients. I know that we're running really low on time. So just in summary, these courts, the treatment, diversion, and restorative justice programs that are in these courts are extremely important. They do a lot of good, but it is important that lawyers understand the programs and their role in the program so that clients can get the full benefit of this justice treatment partnership. Okay.
Okay, we have 3 minutes left and we have a couple of questions in the chat. So we'll pull those up. And therefore, both Holly and Kemi, who went first. So first question is there a restorative justice component in this model where the victim is included in the process, including access to supports?
Okay, that's a good question. It's interesting because when we sort of took our collective experience at looking at this population, we actually found that many victims chose not to participate in restorative programs with the accused. So a sort of a very specific, deliberate decision was made at the Toronto Northwest to allow victims the opportunity to access services independently of the accused. So we offer enhanced services to victims, for example, including the Toronto Northwest social worker who is available for immediate counseling if required. But it's independent. It is not sort of tied to a restorative program. That said, there are examples that we see, particularly with family members, where it's very important for a more restorative justice program. And so there is the option for that, but it was actually specifically created to allow for both models to sort of coexist.
Okay, thank you. This one is for Holly as well. Holly, I know the Downtown East Justice Center has partnered with our agency, Surrey Place, to provide case management for individuals with a developmental disability. Are there plans for the Toronto Northwest Justice Center to partner with a youth agency to help with the individuals that have or suspect a development disability?
Okay, all of our Justice Center pilots, we are operating only in pilot mode. And so we are going to have to be in a position to sort of demonstrate utility and effectiveness as a court model to both the government and the Ontario Court of Justice before we will sort of expand our model. That said, I do want to mention that the Toronto Northwest, we do work with community case managers and system navigators who do make appropriate referrals to developmental disability supports as appropriate. That said, should expansion be in the cards for justice centers at future, I think a partnership of that nature in order to expand our existing model would certainly be under consideration.
And I think just to add to that, there is a mental health group that's meeting in Northwest, a network of agencies that provide those services. So that would be a natural connection. Thanks.
Great, thank you. All right, we've hit the 9:45 mark. We're right on time. Good job, everyone. So we'll turn this over to Dennis.
Thank you, Judy, and I'd like to thank all the panelists. Those were great presentations today. We are now going to go to a 15-minute break, and we'll be coming back at 11 o'clock.
just wanted to say hi, Lauren.
Hi.
Morning. Just plug myself in. Sorry.
Oh,
There we go. How are you?
I'm good. I'm good. How are you doing today?
I'm doing well. I don't want to take you out of your flow. I just wanted to say good morning.
Okay, thanks very much. I think that let me go to full
Tammy
screen.
and I are both here.
Okay, great. So Dennis, I know, is going to come on and introduce me, and then I will introduce the two of you. And
Okay, Lauren, do you mind if we share our screen for the PowerPoint?
You do whatever you want. I'm
Okay.
fine with whatever you want to do.
Okay, no worries.
Your mics are all live. We'll be starting in 2 minutes.
Okay, thanks, Dennis.
Lauren, how do I pronounce your last name?
Sab Say.
Thank you.
Are you able to see it?
Yes, we can see it.
Just let them know that you're.
Okay, welcome back, everybody. It's the top of the hour, and it's my great pleasure to introduce this next session on treatment services for the incarcerated population. It's my honor and pleasure to introduce Attorney Lauren Sabsay, who's a criminal defense attorney and civil litigation lawyer with more than 30 years of experience. He's a certified specialist in criminal law by the Law Society of Ontario and teaches advocacy and legal skills through organizations including the Advocate Society, the Criminal Lawyers Association, the Ontario Bar Association. Attorney Sabsay serves as the executive director of the Canadian Association of Drug Treatment Court Professionals. I would note that Attorney Sabsay is also an accomplished practitioner of the martial arts. I understand has also done some television appearances. Good morning, Attorney Sabsay.
Good morning. Thanks very much for that kind introduction. One of the things that has always traditionally been very difficult in terms of practicing criminal law and having clients who are facing and dealing with various mental health concerns is the inability to have those concerns recognized and dealt with when that client is incarcerated. It's been an ongoing problem and difficulty, as Dennis indicated, in my practice for over 30 years. You know, you have someone come in, someone who might be fluidly psychotic, someone who may be suffering from various kinds of ailments, illnesses, or addictions, and who are in serious need of help that is relevant not just to their welfare, but can be to the case and to what it is that they are facing in the criminal justice system. And it is with great pleasure that I introduce you to two people who are going to talk to you about sorry, I just got to get the name correctly here. The Forensic Early intervention service at the Toronto South Detention Center. And this is really, you know, the more I learned about this, the more remarkable it seemed to me that this has been a project that has been necessary for many, many years, and it's an absolutely fantastic thing that it's happening. And so I'm going to introduce the two people who are going to be spearheading this presentation, and their names, I assume, well, actually, they're both on the same screen. Okay, so you'll see a screen that says Tanya Connors on it, but that's not actually Tanya who's seated in front of that. That is Sherry Thompson-Rutter, and she is the acting manager of social work services at the Toronto South Detention Center. She's a social worker in the Ministry of the Solicitor General and has been since 2017. She's got over 9 years experience, social work experience, dealing with mental health and rehabilitation and reintegration of clients in the criminal justice system. And she has acted on those interests both here in Canada and in Barbados. Also, who's going to be with us and presenting is Tanya Connors. She's a social worker with 20 years of clinical social work experience. She's worked in a variety of settings, including ACT. She's going to have to tell you what that stands for. I don't know. Mobile crisis teams, women's shelters, and the Toronto Drug Treatment Court. She's been with CAMH, the Center of Addiction and Mental Health, for 14 years. And she is the current manager of the aforementioned Forensic Early Intervention Service, or FEIS. So I'm now going to turn it over to Sherry and Tanya.
Good morning. So like Mr. Sabse mentioned, my name is Sherry. I am the acting manager of social work services here at Toronto South Detention Center. And I will start off our presentation and then I'll transition into Tanya, who is our manager of the FEIS team, the Forensic Early Intervention team. Okay, so our initial slide just speaks about Toronto South Detention Center and the transition for the ministry's idea of modernization. So we have the Southwest Detention Center and Toronto South Detention Center, which are amalgamations of other detention centers into who we are here today. So Toronto South we housed clients from the Mimico Correctional Center, Toronto Jail, and Toronto West Detention Center. Toronto South Detention Center has been housing clients from 2014, and we try to address their needs, and that's what I'll be speaking on. So I'm going to walk you through essentially the admission process here at TSDC, the services that we offer to our clients here to assist them in their rehabilitation. So that can be providing services to address their mental health, their substance use, helping them to manage their symptoms due to trauma, and how we help them reintegrate into the community. So there's a little bit about our inmate population. We are a detention center. We are not a prison. So our clients here essentially are awaiting their court dispositions. They are charged, but they're not always convicted. We house clients from the GTA and they attend court within the GTA. Due to the pandemic, a lot of our clients do their court cases here in their detention center online, and we still support them with the resources that they may need. So like Lauren mentioned, we have clients who enter the facility who have many different concerns. As clinicians here, we try to address those concerns, keep up to date with their court matters, and also with consent from the client, speak to their family members and to their legal counsel to address any concerns the court may be looking for. TSDC, our population here, we are a diverse population, which is representative of the Toronto population. And also, our clients here are able to benefit from our diverse staff. So if I use mental health as an example, this is a frequent concern that we have here at the South. Some clients, depending on their country or region of origin, depending on their religion or their culture, may not have great insight into their mental health concern, or they may simply deny their mental health concern. With our diverse staff who may share similarities from the region or country of origin, cultural or religious background, we're able to speak to that client. Through offering psychoeducation, we're able to highlight or give insight into the client's mental health concern. We're able to discuss with them symptoms that they may be experiencing. We're also able to discuss with them the treatment options that they have here, in addition to treatment options that they have within the ministry. And I'll speak about that later as it relates to correctional centers, which are treatment focused. But having a diverse population of clients and having a diverse population of staff members allows us to speak to the clients where they're at, addressing the stigma or the societal taboo that they may have from their countries of origin or because of their religion. Many clients here, and I can speak from being someone from Barbados, mental health is not something that's spoken about openly, and therefore, when we have Afro-Caribbean or Afro-Canadian clients here, some people are able to just speak about the stigma that's at home. We're able to touch on the religious background that we are taught, but still also highlight what a mental health illness is and how we can help. The same thing goes for a diverse team here in terms of matching or speaking to clients in their language of origin, which may seem to be small things for somebody, but for our clients, it makes a significant difference to be able to see somebody who looks like you, who's in a profession, who's able to help you. So right now, I'll walk you through our admitting and discharge process and what that looks like here for our clients. In this process, we are also able to seek those clients out who have concerns. So when a client enters Toronto South Detention Center, they're all seen by healthcare. There's a comprehensive healthcare assessment that's facilitated on their entry. This looks for things like their medication reconciliation. So we try to get as great of a picture as possible of the medication that they're taking when they're outside in the community. We also try to address physical health concerns. If a client discloses that they have mental health concerns or they've had a mental health history, they will be seen by a mental health registered nurse as well, and a screening tool is given to them. In disclosing this information to our staff on entry, they're able to be classified to specific units. So in this presentation, we're looking to help our client to have mental health concerns or substance use concerns. Our registered nurses on entry into the facility are able to classify our clients to specific units addressing the concerns that were brought forth in that assessment. So we have clients who may be sent to our special needs unit. We have clients who may be sent to a unit for stabilization. We have clients, if someone is experiencing significant withdrawal, we're not going to send them to a regular unit. We will have them go to the infirmary where they will be seen and addressed for those concerns. So that's just a little bit about how we process clients coming in here and how we're able to classify them to units to meet their needs. So Toronto South is different to many other institutions. We are a direct supervision institution. We run on a direct supervision model, which is very different from many of our other facilities. So in a direct supervision model, and I'll show you a picture following, there's great interaction between our staff and our clients. Our correctional officers actually work on the unit with the clients instead of being in a separate office or a separate room. This is a progressive model, and it has a greater impact for rehabilitation of our clients. And the layout is very different, so I'll show you a picture of that. So here is an example of what a housing unit in TSDC looks like. So we have our soft seating. Straight ahead, you're going to see a desk. That's where the officers sit. Behind there, we have an interview room. And this interview room is a room where social workers, chaplains, our doctors, psychiatrists, professionals are able to see clients in that room on the unit and provide confidential care to them. And a client doesn't have that sense of uneasiness having to move through the facility as they would somewhere else. It's very important for us in the DS model as well to have a sense of normalcy. So we have our soft seating. We have 2 flat screen televisions on the unit, and we have a yard. The basketball court is used not just for basketball, there is exercise equipment, and there's also smudging for those who would like to do so. Our Indigenous clients are those who are invited to do so. The flat screen TVs on our units help us, or can help us a lot with our rehabilitation. Having these screens on the unit allows for people, it allows for us to disseminate information. So the screens in a DS model can be used for rehabilitation if it's programming to address managing mental health, substance misuse, programming on anger management. Earlier this year, though we have been affected by COVID like everyone else, we have had programs where people address budgeting, building their resume, and we're able to use the technology here at Toronto South with the DS model to help our clients. It provides a safe space, and though they're incarcerated, it gives them that opportunity to understand healthy relationships. And that's what the model is based off of. We as staff here are correctional officers who are there 24/7, model positive behavior. And essentially that's what it's about. And clients have that opportunity to emulate that behavior. They have free access to their correctional officers and also to us as clinicians. So we go, we have conversations, and change doesn't happen overnight. So having this model allowing us to go onto the unit just below the TVs, which is out of sight, we have a program room where we go into the room with our televisions, with DVDs, and we actually facilitate and deliver programs to all clients who are interested. So our model is very progressive. It's there's a lot of interaction with our clients, and that's what we need. We're trying not to build a space where people who are in detention have that fear. Being incarcerated brings with it great fear. It may trigger some people, those who are affected by mental health. There is that likelihood that they may be a bit more uneasy. But this direct supervision model and what we try to do here at TSDC is to help people to adjust, essentially. So I'll speak about our multidisciplinary team, and we have quite a large team. We try not to work in silos here at TSDC. For the benefit of our clients, it's important that we all play our part, and we address our areas of expertise, but we are also very collaborative. So our team, as you can see on the screen, we have our addiction counselors, our SEALs, chaplains, institutional liaison officers, and they are probation officers who work here with us. So we have 2 ILOs, and they work here with our clients and with our multidisciplinary team, and also connect us to probation officers in the community. We have the Legal Aid of Ontario, who we communicate a lot with them. Our Native Inmate Liaison Officer. It's very important for us here that we address the needs of our entire population as best we can. We have a high number of Indigenous clients here in our facility, and our NILO is there to support them with bridging the gap between custody and the community, highlighting areas of need to our elder who supports our clients so that we can help clients while they're housed here in custody. It may look like smudging, circle hearings on the unit, but also helping them to transition into the community, going to Sagate, going to NAMIRES, and just bridging that gap between and addressing their needs while also keeping their traditions close to heart. And that's very important. Additionally, to our team, we have our general duty nurses, our mental health nurses, physicians, program officers. So program officers are unique to some of our institutions, and they are correctional officers, but they've been trained specifically to deliver several programs, which I'll show you later. These officers go on to the units, they seek the interest of the clients. We also get information from assessments that we do that highlight the risk and need areas of clients, and we try to address those. Additionally, we have our psychiatrists or psychologists, our recreational officers who play an integral role here at Toronto Cell in terms of having that meaningful time out of cell, that meaningful interaction. And it's important that our clients have that rapport with our staff. We don't want people to be at Toronto South and sitting in their cell or not interacting with others. So we have specific staff who are there who will meet with them, discuss their areas of interest. A lot of our staff are very well trained, so motivating them to change their behaviors. We also have our rehabilitation officers, social workers, and our volunteer services coordinator. So as we try to address strategies that are to support clients who are affected by trauma, mental health, and substance use, I'm just going to highlight a few of our team members and the role that they play in addressing concerns while in custody, in addition to while they're transitioning out of custody. So first off, I'm going to start with our social work team. I also want to highlight, however, that it's very important to note that clients are given dignity and have the autonomy to make their own decisions. So while many people may believe that this specific client needs help or their family members call and express concern, we do speak to our client to find out where they are in terms of their stages of change. What do they want to address? Some clients may have a substance use concern, but they don't feel it's the time right now to address that concern. We also, it's very important to understand in terms of clients for substance use, do they want to abstain from their substances or are they leaning more towards a harm reduction route? But I just want to highlight that all of our services are based on the client's consent and they have every right to consent to doing so or not. So our social work team here, we focus primarily on case management, discharge planning, and liaison with collaterals in the community. So that may look like tenant boards, that may look like friends and family, and also counsel if people give consent to do so. We're also responsible as a social work team for facilitating programs and completing clinical assessments for parole eligibility. We also facilitate levels of service inventory, which is an assessment that we use to find out a client's risk or need areas. This is very important for us because we do an in-depth psychoeducational assessment, and that highlights a client's criminal history, but it also highlights their mental health history, physical health history. Have they themselves been a victim of a traumatic event? And the information that's output highlights their risk areas of recidivism, but also their need areas. And we as social workers try our best to address those areas if the client is willing to do so. So social workers here, they provide referral forms. So like I mentioned about our correctional treatment centers, we have the St. Lawrence Valley Correctional Center. Clients who have mental health concerns or suspected mental health concerns, those who are experiencing severe psychosis, we try our best to have these clients assessed and they go there. It's a 16-week intensive program. Sorry, that one isn't 16 weeks. You can have a minimum of 3 months before you go there, but you can stay there for 6 to 9 months. The OCI, which is our Ontario Correctional Institute, they address concerns such as those of our clients who have sexual offending histories, those who have substance use concerns, or an antisocial pattern. You have to have a minimum of 9 months to attend this center. And then we also have the Algoma Center, who addresses substance use, but mainly anger management and domestic violence. So essentially, we're trying to help clients not only address their mental health and substance use, but also their criminogenic factors, addressing their criminal behavior and helping them to understand a different path that they have an option of taking and reducing the risk of recidivism. We also have our addiction counselor who assists with referrals into the community, and also our volunteer services coordinator. So we have all of these programs that are offered. We try to address the person as a whole. Yes, some people have been convicted of a crime, and most of our clients here are detained for a charge, but we try to address them as a whole. So addressing their substance use, having them understand the importance of goal setting and changing their habits. Our volunteer services coordinator, these are just a few that are unique to Toronto South. So art therapy, resilient reintegration, which looks at the discharge planning of a client 4 weeks in. And we also try to address overdose prevention here as well. So when it comes to our discharge planning, we try to address a lot of things that we try to address are like determinants of health. And housing is such an integral part of discharge planning. And it's something that we in the city, we have a concern regarding clients leaving custody and may not have somewhere to go. We're depending so heavily on our shelter system, but there's not always a bed available. However, through discharge planning, our social workers do try to ensure that a client has housing upon release. So when our social workers meet with their clients, the first conversation should be about discharge planning. We try to find out all the areas the client wishes to address. And while they're housed here, we make those referrals. We network with our community partners to get them housing or to get them into treatment for their substance use or their mental health. While clients can't apply for financial aid in custody, we do help them to set up appointments upon release from custody. So if we know their discharge date or counsel calls and says this person is going to be bailed, we do our best to set up those appointments so clients can address their financial needs. Some clients are interested in completing school. While this is offered here at Toronto South, some clients don't feel comfortable doing so in custody. And so we work with our district school boards to have clients transition into classes. Applications for work, we try to help with, and like I mentioned, our treatment applications. COTA, CMHA, and Inner City Health are just a few of the referrals that we make for our clients. We do make use of many community agencies in our community to address client needs. And I'd also want to speak on how our mental health team plays a part in discharge planning, specifically for our mental health clients. So they address the methadone or Suboxone use into the community. They connect with their pharmacies in the community to help clients transition. If clients are taking specific medication here, our mental health team does their best to have clients have a 3 to 5 day bridging prescription to allow them time to get to their doctor's appointment upon release from custody. And then our final point will be just to address if a client is sentenced and their date for departure approaches, but they're acutely unwell, our doctors and psychiatrists see our clients, they form our clients, and we transition them to the hospital just to ensure that they are safe and our community is safe. I know this is a lot of information, but I hope that it's given you a greater idea of some of the strategies that we use here, some of the applications that we use just to address our client needs. I'm going to transition you to Tanya.
Thank you, guys. Working in a little bit of a cramped space. So you can see from my colleague Sherry that the Toronto South is a lot more than what you might hear about in the news. And it's a large institution with a lot of hardworking people trying to accomplish a lot of goals and a lot of planning. I'm going to switch over now to tell you a little bit about one of the specialty services, and that is the Forensic Early Intervention Service, or FICE, which is a very unique program in that it is only offered in 2 correctional institutions right now in Ontario, and that is the Toronto South and the Vanier Centre for Women. And it's a unique program, and what you see on the screen here is actually a picture of the mental health unit, and those stairs are now removed. And if you look up at the top in the mezzanine, that's actually where we're sitting today. Our offices are above the mental health unit. So this CAMH service is truly embedded in the correctional setting, and we work closely and in partnership with Sherry and her team, as well as all the healthcare nurses and psychology to sort of bring services. So let's just give you an overview a little bit more about the program. First of all, as I mentioned, we're just one of many programs at CAMH, and I guess those of you in the GTA have probably heard about CAMH, but if you're not familiar with it, the Centre of Addiction and Mental Health is one of the largest institutions in Canada for mental health services. It's quite large. It has many programs, and the forensic stream is just one, and FICE is just one of many other programs. So it's just one little program embedded with many of the CAMH programs. We have geriatric, schizophrenia, addiction services, many more programs. So we're a collaboration, and again, I mentioned it's unique. We're actually a collaboration with the Ministry of Health and what used to be called Community Safety and Correctional Services, now known as SLOGEN, which in itself is a unique idea. So mental health funding has been paired with corrections to deliver services within the facility. So we're an outside vendor, guests in the home, so to speak, of these institutions. We opened in 2015 at the Toronto South and 2017 at Vanier. And so as we know, and research has shown, and if COVID has taught us anything, we also see that mental health, people with mental health issues are overrepresented in the prison population. So CAMH has a famous kind of campaign that they did quite a while back now, 1 in 5 experience mental health issues. Well, actually, based on our research here at the South, I would say 1 in 3 coming through our doors require mental health support. And at Vanier, I would say the numbers are even higher with our women. Maybe 1 in 2 would screen positive for mental health services. Saying that, and as Sherry showed earlier, when clients are admitted into an institution, into A&D here at Toronto South, they're given a brief jail mental health screener, and I'll show you that tool later, but it's a tool that it's very general, and it looks at, have you ever had a mental health admission before? Do you take medications for mental illness? Do you feel followed, or someone could read your thoughts? It's very vague. It's only 9 questions. And if you trigger that screener with 1 or more yeses, then you get a referral to our program here upstairs, the FICE service. And so while we may get, a third of all referrals coming through, the population that we tend to work with and the population that we're funded to see is actually that 2%, that acutely unwell, really unwell population. So we will see all who are referred to us, and then we triage the referrals to see who would actually be suitable for FICE. The rest of the population will be referred back to general psychiatry in the Toronto South Jail. And we work in partnership with this team. We're consultation, but the people we case manage are that 2%. We're a multidisciplinary team, social workers, nurses, occupational therapists. We have daily coverage with psychiatrists as well. We have a great team. And we're a collaboration, right? So the FICE team does not provide the treatment or care to the client. We are a consultation service. While we do consult and support discharge plans, while we do liaise with families and outside caregivers and make referrals, it has to be, first of all, consent-based. The client has to agree to our services. And we are doing that in partnership with the Toronto South team as well. So we can't provide involuntary treatment. The jail is not a Schedule I facility. So some of the things that people sometimes have a misunderstanding about is, well, FICE is there, you can give them their injection, or FICE is on site, you can make sure this person is formed and sent out. That's not how it works. The Form 1s are still written by the Toronto South psychiatry team and their healthcare team, and treatment is not administered in jail. This is not a Schedule I facility, so the only place treatment can be, sort of involuntarily administered under the court order is in a Schedule I facility such as CAMH. So the people that we tend to work with, that 2%, so to speak, is the people who are maybe going down the NCR pathway and not criminally responsible pathway. So they're going to have a long time in the legal system, and their crime may have been, due to their mental illness. So we would definitely stay involved with those cases. If a client is unfit to stand trial or at risk of being unfit to stand trial, or as we say, more like clinical terms, acutely unwell, we would definitely stay involved. If they're going to be sent for section Form 48 or an assessment, we try to work again with those clients to help coordinate their care and work with people that are at risk of entering the forensic mental health system. The other piece to know, of course, is that we only work with people before they're sentenced. So this is an upstream kind of program. If you're sentenced, we're not able to work with you. Once the client becomes sentenced, FICE can't stay involved. So we're that early intervention piece. So this is a little bit about what our program is based on. It's actually under the STAIR pathway, and that's a model of care that was coined by Dr. Sandy Simpson. And we've really started to, this little diagram has really helped provide the framework, not just provincially, but internationally, about services that are required for correctional care. So screening, triage, assessment, intervention, and reintegration. And if you look at that pathway, the screening piece happens in A&D, in the admission discharge bay. And we use the tool, the Brief Jail Screener. And again, the Toronto South Healthcare team uses that tool. The referral gets faxed to us, and the FICE team would do what we call a JSAT. So the triage part is we get a new referral. Every day we get new referrals. We meet in the morning. We look at those referrals, and then we go out across the jail, regardless of what unit they're on, and we do what's called the JSAT, the Jail Screening Assessment Tool, which is a nice biopsychosocial quick assessment. It's not meant to be diagnostic. It's not meant to label people or do a deep dive. It's really meant to sort of do a quick overview of where this person is in terms of their ability to function, what their needs are, what their strengths are, and do they need to be involved with more intensive mental health care. Every day in the afternoon at 3 or so in the afternoon, our team meets with our psychiatrists and we review all the JSATs we've done for the day. And so, for example, if we saw 10 new clients, maybe 4 or 5 of them would warrant further follow-up for our psychiatrists. So we'd further triage them to our psychiatric assessment. The other 5 may have mental health issues, but they're manageable, they're being monitored, they're able to integrate into the population, and we refer them automatically back to the Toronto South. For those that our doctors do assessments for, and we then further decide to keep on the caseload, we look at doing, again, interventions, but the intervention, again, is in partnership with the Toronto South. So we would look at their histories and give the Toronto South access to their most recent medication regime they might have had, or what community supports they may have, what we feel some of the gaps are in their care and what they're needed. And then we would provide what you would call traditional case management services, which is coordinating with their community supports, helping to build a discharge plan, and working towards reintegration. So this is a copy of the Brief Jail Screeners. You can see it's very vague. And when we first rolled this out, the nurses in A&D said, well, everybody would screen positive. We're going to refer everybody to FICE. And to be honest, that's okay. We're quite okay with having more to see than who we keep, because the people that we're really trying to target this program for are those who are quietly psychotic or quietly unwell, who fly under the radar. Everybody knows somebody who's coming through who's manic or yelling or screaming or psychotic or really, mood elevated with substance use, or long time, chronic schizophrenia symptoms, people can see that those tend to be very visual and presenting, for urgent care. But those guys who are quiet, who may seem to be okay until you talk to them for 5 minutes and then they believe the aliens are following them, or there's a chip in their shoulder, or there's somebody tracking their movements or whispering in their ears. Those are the people that often go unnoticed and sadly deteriorate in jail or linger and have their court matters sort of delayed because of undiagnosed mental health. So those are the ones we're also trying to screen out. So the screener is general, but it's done so by design. This is a copy of our JSAT. And again, for those familiar with psychosocial assessments and biopsychological assessments, that's basically what it is. You'll see there's a lot of tick boxes, not a lot of room for commenting, because we really are just scratching the surface to further indicate if they need our services. Somatic concerns, depression, anxiety, hostility, elevated mood, all very general themes. And again, we would do a deeper dive if we felt that they were somebody we want to further consider. That's when our psychiatrist would do a deeper dive. So who we see, as you can imagine, and this was an early snapshot, but one of the things that came out quite early in our research was that out of the first round in our first year, we did an analysis of who came to Toronto South. And we realized that 60 to 65% of the clients that we registered for CAMH already had a CAMH MRN healthcare number. So these are people we know. So 65% of the new admissions to Toronto South were already CAMH clients, which of course is sad, but also speaks volumes and is in some ways helpful because we have that electronic health record and we're able to access that and then provide timely, quick information to the Toronto South that they would otherwise not have access to. So unfortunately, the statistics are true. We saw it in our own program that those who are mentally ill are overrepresented in prison. And the only hope for that is, like I said, we're able to provide good healthcare information based on their previous admissions. Most of them are homeless, and you can see it says like 36% live in stable housing. I would say it's probably even less than that. So that means 70% are probably, insufficiently housed, if not homeless. 70% or so are usually diagnosed with schizophrenia. That's not a surprise. It is one of those conditions that can be chronic and reoccurring and unfortunately difficult to treat and often leads to conflict with the law. And it also says that 94% have been previously incarcerated, which is also sad, seeing that the cycle is not broken and there's a repeat on the admissions. So some of the successes, not just from having the FICE service, but what kind of grew from our program is we now have, and this is not unique to the Toronto South, we were able to help coordinate beds as well for Vanier women at Ontario Shores. But CAMH has now put together a package where there's one currently operational, but there will be scaled up to 5 acute care stabilization beds. And what that means is clients who are here in the Toronto South who are acutely unwell and requiring hospital care and are on the FICE caseload, we're able to streamline the admission straight to our unit, a secure treatment unit, and essentially bypass the emerge piece. They're on a Form 1, and we've done the assessments, so they meet the admission criteria of a Form 1, but we streamlined the process that they can go directly to a bed as opposed to have to go through a very awkward and often difficult screening process at emerge. That bed is in high demand, as you can see. It's been utilized 92, I think it's actually 95 now this year, % of the time. It's a short-term stay. It's not meant to be a recovery long-term care bed. It's meant to stabilize people, get them started on medication, help them kind of get cleaned up and a little bit more focused to be able to continue working through the forensic system. So it's meant to be a stabilization bed, not something that people can take for longer than 3 weeks. Although we've had a few that have gone a little longer. The other thing we're able to do with this unique partnership, which has helped greatly, is that early on in 2018, we applied for a grant, our team, and we were able to fund training for correctional officers, specialized mental health training delivered by psychiatrists on our team and clinicians. And it was a really extremely positive event. Clients and staff were, the staff were very excited that we knew the same clients they did, that we were able to talk about that with some credibility because we worked in the institution. We understood the challenges they face as officers and the limits to the care and operations that they can deliver. And so while it was a really well-received training, over 100 officers were trained, including some at Vanier. What then happened was that CAMH Education and Corrections Ontario partnered, and we now have modules built into the correctional officers training based on that information that we did in 2018. So each new hire coming to the correctional centers has that training that was developed by CAMH. So that was another great partnership. So you can see here, this is just some of our numbers. And things have changed, of course, with COVID, but I would say, if anything, the number of people we were able to complete JSATs on have actually increased during COVID because they're no longer leaving the facility for court. So, but while they're doing video court, they're not leaving the facility. That means they're available throughout the day for our staff to see them. So out of 5,000 new referrals at Toronto South in 2020, 2,100 or so were referred to FICE, and we were able to do a JSAT on just close to 1,800 of those clients. The number of clients that were on our case of longer term is around 500. I would say it's a bit higher than that even, but tracking that data is difficult, but these are clients who had multiple visits with us. So some of the things that are challenges for this program, and those who work with remand populations can appreciate this, is the short stays. Sometimes our guys are admitted on a Friday, discharged on a Monday. We don't get to see them, or in on a Friday, released on Tuesday, back again next Saturday. So there's a quick turnaround sometimes on how we get to see them. We are a consent-based service, so if clients refuse us, we cannot proceed with working with them. We do a kind of a 3 or 4, strikes you're out kind of thing. So if the first day they say, I don't want to talk to you, we totally appreciate that. You just got admitted to jail. We'll come back at another time. But if they're clear and consistent in their no, then we can't concede. We can't proceed with working with them. So it's consent-based. Some of the challenges we come up against in our work, and the officers express this, and you would hear about it, is what constitutes a Form 1 in corrections. So if somebody is on the street corner naked, screaming and shouting profanities, you know what? The police are going to come and put you on a Form 1 and bring you to emerge. If somebody's screaming, shouting profanities in a jail cell, where are you going to go? Are they at danger of hurting themselves? Are they at danger of hurting others? So the bar gets a little higher, and the containment of risk becomes different. And so unfortunately, we see people who, under the Mental Health Act, and that danger to self or others is really contained and mitigated just by the simple fact that they're in a cell. And emerge doctors and those working in the field will say, oh, we can't do anything different here. We're not able to provide any extra for that. So sometimes people get sent out in a form and shipped back really quickly. They might get some short-term medical intervention or medications, but it's difficult to keep them under that Form 1. The other thing, of course, I flagged was that multiple admissions. So 10% of our inmate population that we work with in FICE have been admitted 4 times or more. And those, the frequent flyers sort of thing, it is so difficult because housing and all those social determinants of health pieces are very hard to line up. And those ACT teams or assertive community treatment teams, they have wait lists. And so these guys often fall between the cracks and are cycling in and out of shelters and homelessness and back into jail. There's also the bed shortages across Ontario. And so who deserves a bed? That stigma piece. So a guy comes in through Emerge in a jumpsuit with 2 correctional officers shackled, leg irons, and they're hoping to get admitted to a mental health bed. Well, the whole Emerge now is probably a little bit, nervous and uncomfortable and wondering what's happening. And unfortunately, the milieu of the hospital setting is often kind of like, oh, this guy needs to go back to jail and he doesn't belong here. And unfortunately, people who work in corrections know that stigma, and it's unfortunate that's still a hangover, so to speak, in terms of the general society's view of our guys. So there's the stigma. And also, of course, the limits of our program is that we're only available in 2 Ontario hospitals, in 2 Ontario jails right now. And across the system, there is a great demand and inquiry about why FICE hasn't been rolled out in other places. And that's something that we'd be more than happy to help coordinate, but of course, it's not in our hands to just expand our funding. But it is something that's definitely sought after, and there's been an expressed interest. So that's everything. Now I'm going to turn it over. If you have any questions for either myself or Sherry, we're definitely here. I'm going to see if I can put Sherry in on the screen as well.
Hey, so while you're doing that and oh, I see, there you both are. It's great.
We are here in the same room.
All right. So what I'm gonna do is I have some questions for both of you, and I'm going to, but I will monitor the Q&A, and if anything pops up there, I'll bring it to your attention. So the first question I have, Tanya, since you're closer, I'll start with you. That screening process, and you showed us the brief jail mental health screen, for example, and that can trigger, you know, the people who you've referred to either as clients or our guys to see FICE. What happens in other institutions that don't have a FICE? It's a two-part question, really. One is there that kind of mental health screening assessment that even goes on at other institutions? And two, if there is, what happens if there's something that would, at Toronto South, trigger a FICE referral?
Yeah, so in other institutions, Corrections Ontario did implement the brief jail screener across all institutions, and the JSAT is being done. Usually, I think the social workers or the nurses at other institutions are completing them. And of course, in an ideal world, that sounds okay, but in reality, the staffing model was never designed for that. So those frontline workers now, the social workers at Maplehurst, for example, or Toronto East, already have a long list of duties, and now they're being taxed with doing an extra set of work that's, you know, was never really designed in their program. And the JSAT, the brief jail screeners are being done, and they do trigger the JSAT, but they don't have the time or the luxury to have that specialized mental health care that FICE brings. So it is being followed, but to be quite frank, they don't have the resources to bring what we do. And it's not, what's interesting to note is that it's not that the Toronto South social workers or nurses aren't stellar and amazing, is that they have 1,200 or 1,560 if they were full other inmates to deal with. And as you know, in corrections, everybody needs a discharge plan. Everybody wants to have conversations with family. They need coordinated care, and they're trying to do the mental health specialty work off the side of their desk. And that's the piece that we bring. We bring the specialized care and the extra resources and the electronic health record, quite frankly. Toronto South doesn't have an electronic health record, nor do they have access to the history we would by going into our medical records.
Okay, thank you for that. Now, in terms of the JSAT that you mentioned, I noticed up in the left-hand corner that comes from something called the BC Mental Health and Assessment. I didn't get the last word, but yeah. I assume that BC stands for British Columbia, and which leads to the next question. Is there a FICE type of program in BC, or for that matter, in other provinces in Canada?
I'm not sure what's rolled out recently across Canada, but I know in British Columbia that the tool that we're using, developed by Tanya Nichols and a group, was meant to do triage right down in the A&D admissions. So they actually do a JSAT and have specialized workers that do the JSAT in admissions and use it as a triage tool for placement on units. So it's not being used in the same spirit of the way they used it in BC. BC, they have workers that are saying, okay, this person has this mental health issue. He goes on this range based on the JSAT. And for us, we use it afterwards, after they've been placed on a range. I'm not aware of any other FICE services right now across Canada, but I know there's definitely an increased interest in having more mental health integrated into corrections. So that's been something they've looked at across BC, I believe, and trying to contract out and integrate more health into the correctional setting. I think one of the things that makes it very unique, and we learned from day one, we have very different mandates, right? So the Ministry of the Solicitor General is all about security, protecting people, protecting the community, risk assessment, which is what you want your officers and your jails to do. Ours, of course, is healthcare, which is treatment, care, rehabilitation. So we have very different mandates coming together, very, very different models. And the overlap is the place where we can work together. And so why not have specialist services partner like that?
Okay. And here's I guess, a typical criminal defense lawyer kind of question. Because you mentioned that you do work with people who are either have fitness to stand trial issues or not criminally responsible or NCR issues. And so my question is this: what, is there any warning given to those clients about, look, I have to tell you before we start talking about what happened or what's going on, that, there's no privilege here. I could be subpoenaed by the Crown, because when I've run NCR defenses, that's what I get. Oh, they're asking to see me at the jail. There's a jail doctor or a jail social worker. Should I even be talking to them at all? And how do you deal with those kind of issues?
So first, again, as you mentioned, we're a consent-based service. So we don't speak to people unless they give us written and express consent. And we don't speak to the lawyers unless, of course, we get consent. The other piece is we're not interested in their trial. We don't have any weight in our team. Our team is not looking at fitness or measuring fitness. We're trying to look at mental health care and level of functioning, ability to work with us. So if a client wants to talk about their case, first of all, we do a general, consent speech about how we work and who we share information with, which by default automatically is the South. We have to share information with them. So we explain that. And then we tell them, we don't want to know about your court issue. We don't want to know guilty, innocent, what your plea is, what you're doing. We want to talk about that. We're here to talk about your health and wellness. And we really try to make a firm line about that. We don't want to talk about, did you do it? If you didn't do it, what you did. And our clinicians are really trained to sort of stay out of that. That's why from a healthcare perspective, I talk about it as we're dealing with acutely unwell clients who by the legal system might be called unfit, right? So we walk a fine line with that. We haven't had, I think once we've had a clinician subpoenaed, but at the end of the day, the information you would get is coming through the CAMH health record, and you can just request their notes. Our notes are all on CAMH at the CAMH health records.
Okay, all right, thank you. Now I wonder if you and Tanya, you and Sherry can just switch places, and I'll direct some questions to Sherry.
Sure.
Okay, so Sherry, you'd mentioned, of course, what happens at the South and some of the what I assume are unique features of the South, and starting with the admissions process and the screening, and I talked a little bit about this with Tanya. So, what is the training of the people before they get to a place like FICE, before you see them, someone screening them right at the get-go? And I assume those are correctional officers, maybe I'm wrong, but who's doing that? And you're shaking your head no. So who is doing that, and what kind of training do they have to look for things?
So the individuals who are in our A&D, they're registered nurses. So they're nursing practitioners, and they're also then, if a client discloses mental health concerns currently, or if they have a history of mental health concerns, they're then further seen by a mental health registered nurse who addresses those concerns. And then they play their part in having the client classified. So what Tanya may have mentioned in other institutions where the JSAT is that precursor for classification, the mental health team or the mental health nurse will then, depending on what the client discloses, classify that client to a special needs unit where we house clients with mental health concerns.
Okay, so here we've got 4 minutes left, and so I'm going to ask you this next question, which may be the most difficult one, and may take up the remainder of the time, maybe not. So I'm sure you're aware that in February of 2017, Toronto Life magazine published an article in which they referred to the South as the $1 billion hellhole and described it that notwithstanding the best intentions, a lot of which you've told us about, it was a, quote, house of horrors, end quote. So first of all, I want to ask you if, you know, how accurate that kind of thing was at the time, whether it's still the case, because nothing you've said suggests that it's anything like that, or if there's any changes since 2017 that have occurred at the South.
Well, unfortunately, I can't speak to that article. I can speak to what we do here presently and how we try to address the concerns. Toronto South is trying to be a modern center, a place for rehabilitation and reintegration of our clients. And we try our best to hear the needs of our clients, hear the needs of our staff, and address those. So for instance, we have addiction counselors. Addiction counselors were only at Central East Detention Center, and I want to say Hamilton Wentworth. And now the province has heard the cry of our clients, and as well as our social workers who will be helping these clients. And now we have 57 addiction counselors throughout the province. So while I can't speak to the negative article, I can speak to the work that we are doing here, the collaborative effort that we are putting in place, not only with our multidisciplinary team, but with consent, speaking to lawyers, speaking to our community agencies, and addressing those needs. While we are a detention center, we're unable to delve deep into someone's trauma, but our psychology team addresses acute concerns. So every member of our team, if it's a correctional officer, if it's a chaplain, we play our part. So unfortunately, I wouldn't consider a hellhole. We do our best to address our clients' needs and address the needs of the community, to have people who re-enter society address their concerns that may have led them to be here in the first place.
Okay, I think one of the concerns that you know that was there was that, you know, the design of the place, which you talked about,
Yeah.
lend itself to safety concerns. You know, having corrections officers in the same space as inmates and all that sort of thing.
Yeah.
Is that an ongoing problem, or is it not, or?
So our model is simply to have that idea of reintegration. Corrections is going through a sense of modernity. Historically, corrections was seen as a place of punitive action, but now we're moving towards addressing mental health needs. As Tanya mentioned in her slide, we see the number of clients who have healthcare concerns. So while we're not justifying the actions that they have been charged with, we are trying to address the concerns that may have led to negative behavior. Right. So the setup of the unit, while in other detention centers or other institutions, people are very familiar with a behind the bars system, the setup having that almost open concept allows people a sense of normalcy. It breaks down the barriers between our staff and our clients and breaks down that fear and hate. So I would say that having a direct supervision model actually increases a person's sense of normalcy, but also an understanding that while they're housed here, there is help. While they're housed here, each staff member will play a part to model the behavior that they too may want to follow.
Okay, thanks. Sorry.
Can you hear me, Lauren? If I can just add quickly to that, one piece I wanted to say that COVID has demonstrated about the Toronto South is that the design, the layout of the physical plant has been a blessing, because we've been able to contain and support other institutions with outbreaks. So because it's so big, because there's a sense of being able to have units closed or open and inmates separated, it's actually helped stop the spread of COVID, and other facilities are using this as an overflow space to help contain COVID. So it is a different model. It's a relational security model. It is a switch from what people thought of in the past, but I've seen, being here now several years, that it does work. And when properly, you know, staffed and implemented, it makes a huge difference. And like I said, the COVID piece for sure really demonstrated how efficient it could be.
Okay, great, great. Thanks very much for that. I see that Dennis's camera is back on, which probably means we're getting the big hook right about now.
I just want to take the time to thank our presenters very much for a very interesting presentation. Attorney Sapsay, thank you very much for moderating this session. We are now going to a luncheon break. So we'll see everyone back at 1 o'clock. Have a great lunch, and we're looking forward to the afternoon.
Thank you.
Thank you.
What's that called? Oh, okay.
Jen, are you there?
Hey,
Okay, I'm not going to go on camera because I am not appropriate to be on camera.
all good. All good.
Did it work now? It's better.
You took it off, didn't you?
Yeah, so I screen shared to it automatically stop your screen share.
Yeah, but that's okay.
Just stop screen share, but you can access everything now.
Yes, thank you.
Okay, perfect. That was weird.
can't-
It might have frozen. Because if you press escape and it doesn't work, usually that's what happened. Is it froze?
Okay, thanks.
No problem.
I can't do this right now.
You're so good at this stuff. It's just sometimes Zoom and stuff does that. Whatever.
We'll blame it on Zoom. Good idea.
Yeah, exactly.
Yeah.
Okay.
Okay, thanks.
See you later. Bye.
Bye.
Hello, everyone. Sorry about that. My computer just suddenly decided to die and stop charging 3 minutes ago. So I was just always running, trying to get this done. So I'm just gonna put up my slides. I think I'm not gonna go with the slide presentation view because it takes over 2 screens. It's really quite clumsy. So unless you all have a trick for it.
I'm not a good trick person.
So can you see that?
I can see your whole screen and the slides in the center.
No, not supposed to be doing that. Hold on. I picked a particular window. Let's try that.
Let's see.
Better?
Yeah, I can't see your desktop. And then, so I can see your slides on the side and then the principal DTCs, that slide.
Yeah, I can't put on this slide, this mode, because when I do that, it takes over both screens and then I can't see anything. I can't see the room. I can't see. So I'm just going to leave it with that.
Sure.
And there is a way around that, but I can't remember how to do that. So if I do this, so which room do you, which screen do you see? You see the one?
I'm just seeing the one screen, principal DTCs.
Screen?
Yeah.
I can't get rid of this other screen because now, well, this might actually work.
Okay.
Might do this because I can actually still see you now. It's just you're overlaying on the presentation slide.
Okay. Well, as soon as you guys get going on this panel, I'm gonna go off camera anyways. So that could work. And it looks like, I think this is probably what you did, but Irene wrote, Hannah, you can minimize the presenter view in the chat here. I think that's probably what you did though, right?
Minimize the presenter. I wanted to minimize this one. Oh. Yeah, there we go. Oh,
awesome.
There's the tip and trick I needed. Thank you.
Okay, so you got about 7 minutes, so we can just hang tight until we are ready to go at 1 o'clock.
Okay, so I'll stop sharing. Let me do that. Perfect. I'm gonna try that one more time, just because I've just been hacking back.
Yeah, that works.
Okay, perfect.
Hi, Arla.
Hi, everybody. I just also got one of those messages on my computer saying your internet is unstable. So hopefully, yeah.
Oh my God. Mine was, you have 5% battery left, and I'm plugged in, and I'm like, what? I'm like checking all the cords and it's the charger. So then I had to run downstairs because I'm in my office, thank God. And there's people down there. I was so happy. And somebody had a charger.
Oh, good.
Give me another computer over here. Just offices are great.
Okay, so we're still technically recording, just so you guys know.
Yeah.
The session starts back up at 1 o'clock. And Arla, I think the plan is I'm going to introduce you and then you'll introduce the rest of the panel.
Okay, sure.
Cool. Okay. So just hang tight. I'm here if you need anything. I'm just going to go on mute, keep working away, but I'm here if you need me.
Okay. Okay, just a few minutes, I think we have before we start here, eh?
Yeah, I was just going to ask, but we're not presenting. Do you want us to have our video off? Or does it matter?
I think it's helpful to have it on personally for people, but you know, I don't know if there are any hard and fast rules. What do you think, Irene and Hannah? Are you good with that? And Jennifer?
I'm good with having it on. I know what it's like to talk to a group of people that you cannot see.
Right.
I think the helpful part is just to have to push mute if you're not talking, but
right.
I too have spoken to dark screens and it's challenging. So if that helps, go for it.
Yeah.
Yeah, no, I prefer to have my face out there such as it is. But no, here at a lot of the presentations, they ask everyone to mute or darken their screen. So it's always kind of surprised me, but I think there's some people argue that can be distracting to the presenter. I don't really get that, but anyway. All right.
Yeah, sounds good.
All right, good afternoon, everybody, and welcome back to the afternoon sessions of our virtual conference. I am very pleased to get the next panel underway. It's titled Monitoring and Evaluation. We have a wonderful presentation lined up for you, and I have the pleasure of introducing Arla Liska, who's going to be our moderator today. If I may, a little bit about her is that Arla has more than 30 years of experience in the provision of human services, ranging from direct service to executive management and consulting. As a consultant to Calgary non-NGOs for 10 years, Arla assisted in evaluation design and implementation, research, program design and development, strategic planning, and multidisciplinary partnership. For the past 8 years, Arla has worked as CEO of the Calgary Drug Treatment Court. Arla is a passionate advocate for drug treatment courts. Her experience supporting startup of the Calgary DTC program in 2007 to 2008, and now as CEO, provides her with a solid basis for understanding processes involved in developing a highly effective DTC program. So without further ado, I'll turn it over to you, Arla, and I look forward to hearing what you guys have to say.
Thank you, Jennifer. Good afternoon, everyone, or good morning, depending on where you're coming from. And welcome to the session on monitoring and evaluation. The focus of this session is going to be on how to establish monitoring and evaluation processes and why it's important to evaluate our programs. And just to tell you a little bit about the format, first of all, we have 3 presenters today who I'll introduce in just a minute. We'll have a few questions throughout the presentation and that we encourage you to participate in. I'll place the questions in the chat and you can respond back in the chat. And we will also have some time at the end for questions. But please do, if questions come up for you during the presentation, please do put them in the chat so that, and I will monitor the chat and then we'll make sure that we get all the questions answered that come up. So I'll introduce our presenters now, starting with Dr. Hannah Scott, who has participated for over a decade as part of the Durham Drug Treatment Drug Treatment and Mental Health Court Steering Committee in Oshawa, Ontario, as the university partner providing help with research and evaluation. She is full professor and founding faculty member in the Faculty of Social Science and Humanities in Ontario Tech University. Hannah has a master's and a doctorate degree in sociology. Her specializations include victimology, workplace bullying, evaluation, statistics, and homicide studies. She's worked in the United States and Canada on several interagency initiatives, including a community safety initiative in the US and a national homeless initiative in Canada. She was founding director of the Center for Evaluation and Survey Research at UOIT and served as director there for 4 years. Michael Weinrath is professor and founding chair of criminal justice and director of the Justice Research Institute at the University of Winnipeg. He teaches program evaluation and criminal justice policy courses for honors and graduate students. Over the past 10 years, his major evaluations have included drug treatment courts, mental health courts, diversion and restorative justice programs, therapeutic communities, and adult and youth intensive supervision probation programs. In addition to technical reports for the federal and provincial governments and NGOs, his evaluation work has been published in the Canadian Journal of Criminology and Criminal Justice in Australia, Manitoba Law Journal, the Canadian Journal of Community Mental Health, and the New Zealand Journal of Criminology. And Irene Hoffert is the director of Synergy Research Group, a well-known and respected Canadian consulting firm in Calgary, Alberta. Irene has been providing research and evaluation services to the nonprofit sector, government, and funding organizations for almost 30 years. She brings expertise and skills in developing and implementing action-based and participatory research approaches and is also well-versed in traditional research and data analysis methods. She has a track record of over 60 research and evaluation projects with a focus on domestic violence, homelessness, addictions, children and youth, Indigenous and immigrant communities, seniors, and many others. Over the last decade, Irene has particularly focused on research and evaluation of problem-solving courts, including the Calgary Drug Treatment Court, where she's developed and implemented research methodology and tools, produced analyses and reports, and used a developmental evaluation approach to support program development. Irene believes there are many groups in society that don't have equal access and opportunity to access services to address their needs, and that consulting support can enrich the service delivery and assist agencies to improve sustainability, capacity, and performance. So to get us started off, I will now hand it over to Hannah. You're muted there, Hannah.
There we go. I'm having a lot of technical difficulties today. If I suddenly disappear, it's because my battery died. We have no idea why that's happening, but it looks like it's charging. It just doesn't say it's charging. So we have questions for people. And so one of the questions we wanted to ask, we're going to sort of start each section with that while you're presenting, is how many people have actually have a budget for evaluation, whoever's in the room. So if you could just put an answer in the room like yes, no, don't know, not sure. Maybe we can sort of get a sense of what's going on with respect to evaluation in the group. While you're doing that, I'm going to put up my slides. There we go. Can everybody see that? Excellent. Okay, so this is me. As Arla said, I have been working with an unfunded court in Durham region in Canada for the last 10 years. It's a different kind of relationship that we have than the other group centers. So I hope to provide a very different kind of perspective on evaluation, and most importantly, why it's so important to do evaluation. So, well-known fact in drug courts. In the most effective courts, the research shows with respect to drug courts, they all have evaluation built in. This is especially true in the United States, where there's a lot of many evaluative studies to show that the best courts that are most cost effective, that are most effective for clients, that have the best programming, that see the largest successes, tend to be ones where the evaluation is built in and funded. So in Canada, in the United States, it's a sort of national funding program, and then it's also supported by the states. In Canada, we have a hodgepodge of how we do this as we start to get the legs underneath us on drug courts and drug treatment courts across the country. So today, as I said, we have the no funding model, which is me, and it's a research partnership. So they found a volunteer, a researcher, and I help them with their evaluation. Mike has been working in grant-funded, supported research partner, the research partners at the university, and he's done many evaluations with that mode with a lot more stable funding. And then we have the private partnerships as done by Irene here, and she's going to talk about what she does and how she does it. So there's very different ways of doing things with very different kinds of partners. So we hope you get something out of that. So you know these things, you know the 13 principles of drug treatment court, but I wanted to draw your attention to the statement here, which says these are principles for successful court-directed treatment and rehabilitation. And so again, the evaluation research shows that when you build in evaluation and question what you're doing and see if it's working, this actually, as long as you adhere to all 13 principles, you tend to have a well-funded court. And so I'm here to talk to you about number 8, which is right there. So this is number 8. It's mentoring and evaluation, measure the achievement and program goals and gauge effectiveness. And so I'm here to say, why would you bother? So no budget, I'm saying Brandon, no budget. Yeah, okay, I feel you. So when we do this, Meeting principle 8 is a bit of a challenge, right? Because they want the court to operate, but then nobody really wants to pay for funding, and it's an interagency effort, right? So then it's a, if everybody's putting in a piece, then who's going to be paying for that? The courts and counselors are busy. Certainly mental health counselors are busy. Many of the people, it's very hard to get done. So meeting principle 8 can be very hard when DTCs are unfunded, but it's also when evaluation is not built into the partnership participation. So when you're thinking about a court, or when you're thinking about developing one or improving yours, build in that evaluation into your grants, into however you're getting funding. So there's also a problem when there's no buy-in into the court. So on one hand, it also happens when we sort of prioritize the client and the treatment and the medical side of things and the court side of things, but we don't actually evaluate what's working and when it is. So we often hear things like, well, the clients are most important. We don't have time to do the evaluation. We have no money for that, right? Treatment is important. And we have to really reconsider those thoughts. And when there's unequal participation in the court evaluation process. So for example, in medicine, we see a lot of participation in evaluation. It's sort of a requirement on the health side, but in the courts, maybe not so much, or they do it in fundamentally different ways. And or the police may not be, the best evaluation partner. And the court does require that all these people work together and that it all be funded. Somebody collects the information, and it's good to have a third-party collector to protect the privacy of all of those agents. But it is a crucial factor. So why evaluate? I'll give you a couple of very quick stories. Everybody remembers the DARE program. It's that famous American program, Say No to Drugs, right? It's about trying to discourage children from taking drugs. And it's an after-school program for the most part and funded in every state. And now in parts of Canada as well. But the evaluations of it are mixed in the sense that some larger evaluations said that the program actually didn't work. And it was because it wasn't adhering to the original principles of its program. People were coming into the program, children were coming into the program. When they're picked up after the program, it turned out that the children were more likely to not do drugs. But in some cases, young kids were coming to the DARE program and then they weren't being picked up and they'd congregate and sometimes they'd go do drugs. So in the long and the short of it, meta-analysis shows that the DARE program works usually in the first younger years for the program, but not necessarily as effectively. The program has to adjust and change to deal with the older needs of youth. Another example is community policing. Again, there's ways to do community policing under the original model. What they found was many people had community policing programs that weren't working or they didn't feel that they were being effective. And what they found out is that, again, it had to be done in a certain way. Certain things had to be done. And those programs that were not adhering to the principles of community policing were actually not doing as well as others where they were. So I have the study here by McDonald that said it really didn't affect violent crime, but what it did affect was things like property crimes and so on. So again, trying to figure out where you're effective can be an important role here. So typical concerns we hear about this. So we've heard them all, right? And you can add what you've heard in the chat if you want to. Typical concerns, it's house cleaning. We don't need to do it. It's not that important. Client is the priority, right? It's expensive, right? Because when you tell people exactly, when you talk to people like me and you say, what do you need to do this? You say, well, I need I need to have a TA support or a research assistant. I need this. It can get expensive and people don't want to build that in. And they also may not have funding models that allow you to fund other people outside your institution if it's a third-party collector. And it may not be, there's a concern that it may not be favorable, right? We hear about that. Oh, well, what if it's not working? Well, if it's not working, you don't want to be doing it, I think. But I'm going to show you some examples of why we don't need to really think that way. And if the program's not working, we can do stuff about that. But we also have these concerns as the evaluators, but we're not there to hinder the program. We're there to help the program. And this is evaluation and not confirmation, right? Like we want to see what's working, but we also want to see maybe disregard what's not working and save some money. Because remember, every time you're doing something that's not working, you're wasting time and you're wasting money. So evaluation ultimately is cost savings. And I would like you to think about that, even though you see the money going out on the outside, it's because you are making your program as efficient as possible. So trust your team, embrace constructive feedback. You have to buy into that. Remember, you're gauging effectiveness and engage in open dialogue. So really question your program. What are you doing? What have you added? Is it working? Does it enhance the program? Is this helping or hurting the client? Are they just going through this and it's not helping? In that case, there might be, other ways to try to help. So I'll give you an example here of a process evaluation by a student. It was an undergraduate thesis project. I use an unfunded court, so you can have a research partner. I have a student who was interested in drug courts. We just set it a standard evaluation. Is the court adhering to the 13 principles of best practices? And she found that, in fact, the court was not. This was my court. But interestingly enough, what they weren't being able to effectively do were the things that required money. So they were having trouble funding, for example, urine tests. They were having trouble funding anything else that required money in that program, right? And so what we ended up doing here is using this study to fund or to provide evidence for funding and grant funding. And so now our courts are able to have some more funding as a result of this study, because they know that the most effective drug courts do adhere to all 13 principles, but funding is a huge part of it. So the answer was yes and no. The suggested court's not working, but where it was failing was due to lack of funding. And so the study was used to support funding efforts. Another example is, this was a master's student of mine. She was interested in whether or not there's sort of a suggestion that if you go to drug court, that you would stop using emergency departments as much, because they were showing up prior to the treatment and prior admission to the drug treatment court in ED, using the emergency department as a family doc. And so we figured that this would be something that would go down. And in fact, we found it went up after graduation and during the program use. And we were like, but we took it to the court, the DTC people, and said, what might be going on here? And certainly the addiction counselors did talk about the fact that once you, of course, shed addiction, or you start the process of shedding addiction, that you start to pay more attention to your health. And so they are more likely to present at hospital. And so out of this came a really good discussion about whether or not to integrate something like a family doctor, if we could, so that we could start addressing the health needs of some of the recovering clients that we were seeing. So yes and no, right? Didn't look like a success, but in fact, it is a success. And now the court is using that information and seeing if they can find a GP to help. It's challenging in our community, but we're trying. And then we'll evaluate that. So evaluations work for drug treatment courts to support funding requests. So evaluation makes money. Not only does it save money, it can make money if you know and you have the reasoning and things. And the people who follow me are going to, in this presentation, are actually going to show you how to do that and what to collect. And so hopefully you'll have some good tools in your toolbox to save money and make money, not spend money, right? So it evaluates successes. It helps you determine what success looks like as well. Some successes, absolute abstinence is one form of success, but certainly there are other kinds of measures of success that you could use through the program. It enhances the programming, it enhances the treatment to the client, right? Because it's as evaluated, if it's working, it's the best treatment for the client. And it sparks discussion and reflection. And this is something that the program really insists on, is that number 8 principle, that is the magic behind the evaluation. So no matter how they're funded, evaluation is key. Now the trick is, when you're not funded, the evaluation in my court is sporadic due to availability, because it's purely volunteer and I have to bring students in who are interested in the process. I wouldn't recommend it, and I think Brampton understands that. But there's other funding models here that are great, that are going to be demonstrated. So I have this picture of scaffolding here. Scaffolding supports the structure, and certainly evaluation is one of those big scaffolding pieces that help support the DTC and make it run efficiently. Other things to consider here, almost done, is that these analyses take time. They don't go like that, and you have to build it in the process, right? So lack of consistent funding, though, can actually become a sort of a spiral down the drain, right? So the idea is that if you can't get consistent funding, you can't necessarily show your programs are being effective, which means less funding. So it can reduce chances for further funding. It can create challenges for continuing to help a client, for example, in a consistent way, because you're not necessarily absolutely sure. You just sort of know or you think it is, but document if it's a success and put that down to help the client. What we end up with is we don't fund a court. There's a danger of running a self-fulfilling prophecy because unfunded court used to get no funding, can't operate as effectively, and ceases to be as effective as it could be because it can't meet the principles of the funding parts of the 13 principles and so on and so forth. And there's research to support that not doing all 13 is actually detrimental to drug courts. So thank you for your time. I've chosen this sort of stairs and scaffolding image to sort of, lifting us up as we go. And hopefully I've done that in this presentation. Thank you.
Okay, thanks. Thanks, Hannah. So just to just as a segue into the next portion of our presentation this morning, I've just placed a question in the chat. I hope you all received it. And the question is, when is the best time to start an evaluation? At startup, after 2 years, or after 3 years? So if you just want to type 1, 2, or 3 in the chat, we'll see what people think about that, and then we'll hand it over to Michael.
I think actually it was my turn to kind of shifted things a little bit.
Oh, pardon me. Okay,
That's
sorry.
all right.
Did I get that in the wrong order?
No worries. It was kind of a last minute thing, so no worries at all. And I think the question we were going to ask to precede my evaluation, my presentation was around outcomes, right? And whether or not people were able to or are collecting outcomes. So we'd be interested to see that from you guys while I'm talking. So I'm going to share my screen now. So people can tell me if they can see it. Perfect, thank you. So so first of all, let me just say, Hannah, I think that was an awesome case for evaluation of drug treatment courts and evaluation in general. So it's really important, I think, for us to have that understanding of the value of why we're doing all this work. So thank you, I really appreciate it. So my portion of the presentation today is more about practicalities and how-tos. And I'm going to talk about my experience with the Calgary Drug Treatment Court and what information we gather. So my role there has been as a supporter and evaluation and a consultant, starting with 2007 when we first submitted a proposal for the drug treatment court in Calgary. So it's been quite a wonderful experience, and I've learned a lot and hopefully can share some with you. One of the things to say is that as Hannah was speaking to, not many drug treatment courts have funding for evaluation. And so, a lot of what I'll be talking about assumes that there's at least some dollars available for people to do it. But as I speak to the how to do evaluation, or at least how we're doing it, I'll also identify some of the pieces that are critical to collect. If you're not able to collect it all, at least there's some portions maybe that you can gather. The other thing I'll say too is that there's a different amount of experience with evaluation out there, and some people are really familiar with some of the basics that I'll be talking about, and others, this will be new. So for those of you for whom it's repeated information, please share in comments any kind of suggestions or comments about your own experience. I think that'll be also helpful. So what are the building blocks of the evaluation? So this is whenever you're collecting data of any kind within your organization, these are the three basic building blocks that, if you boil it all the way down to the most essential components, these would be it. And so we've got three things. One is, who is the participant? Who is the person that you're working with, that you're serving? What is their background? You know, we need to understand that so that we can support them and we can understand the kind of experiences people come with. What are the services that we're providing? And so this part of that piece is around monitoring and making sure that there's fidelity to the model, but also looking at what actually happens in the program to support participants. And then finally, outcomes to how are we actually addressing people's issues and people's needs. So quite often what happens is before you go in these directions, you start out with some kind of a, now I'm going to put some terms out there, theory of change or logic model or measurement framework. Essentially what those are is they allow you to put together these three elements in a way that makes sense within your organization and for your mission and for your vision. So that is something that I would suggest to everyone to do, even if you don't have any money. To do a little bit of that kind of thinking about what is it that you're trying to do in your organization and for whom. So I'm going to talk about each one of those three basic building blocks, and just from the using the example of Calgary Drug Treatment Court and how we collect those data. So first, again, building on a lot of what Hannah had said, you know, why do we need to understand participants' needs, for example? Well, I mean, at a basic level, the case managers need to know what people come with so that they can plan services. We also, it's really important to understand what are the different groups that we're serving, you know, so we might have people coming from different countries, people coming with different kind of criminogenic involvement, different genders, right? And all of these groups come with different needs, and we can't just look at everybody with the same kind of paintbrush. So we also want to be able to engage fully and effectively with other service providers out there in the community, so that, because drug treatment courts cannot provide everything, cannot address all needs. So it's really critical to work together with others. And by understanding participants' needs, we can also understand what service gaps might exist out there and then advocate for some of those service gaps. So what do we gather? What kind of information? So this is real practical piece now. What information do we actually gather about participants' experience? And you can see at Calgary Drug Treatment Court, we gather quite a comprehensive set. You know, each of those statements there comes with its own list of things and detail. So, but I just want to maybe share with you a bit about how we do this, because that's a critical piece. One of the things that happens maybe for people that might be new to evaluation or that might not have you know, a full kind of understanding of the depth of what is intended, is they perceive us sitting there with a, you know, clipboard, checking off, you know, people's responses to questions. That is not, from our perspective, that is not the most effective way of gathering information. In fact, what we want to do is integrate evaluation within service delivery, so that, you know, for example, when we first meet the client, the thing we want to do is establish a relationship with them. And that happens, you know, sometimes over multiple meetings, right? And so we collect this kind of information in that type of relationship-oriented conversation. We have at a drug treatment court database, so I know people without money will say, what? And that's been really, really critical for us, because then we can have that information at our fingertips. So, for example, I can tell you that our participants, when they come to the drug treatment court, 73% were physically or sexually abused in childhood. So quite a significant number are, you know, traumatized. So as a result of that, many have started using, on average, they start using drugs at 13. They start engaging in crime at 19. And most, I think 90%, have no legitimate employment. And about, we actually have a number where where they spend on average $2,100 per week to purchase drugs. You know, so this is an important, like that kind of description really tells us about who we're serving. And that's this high needs, high risk group that is the one of the piece of guidelines of the model. So participants is one part of gathering information. The other part is what are the services? So what actually occur? What actually do people participate in? So so we can use service data to understand whether services we're providing are aligning with the needs of the participants, right? And to understand gaps in service overall and in relation to various subgroups of participants. So just to share with you some of the gaps that we're experiencing in our area, this is Calgary. So, but probably it's consistent across Alberta and even maybe some in some of our rural areas or more remote locations, it would be worse in those areas. So we have fewer addiction treatment services for women, which results in delays to access. Some men's treatment facilities do not address trauma. There are some places where culturally appropriate treatment services are limited. You know, so for example, if you're working with Indigenous communities or Indigenous clients, you know, the access to elders and ceremony and all of that is really important to have in order to engage people. There are barriers to treatment access for pregnant women. There's lack in availability of childcare for women. So we are collecting this access to service data helps us understand what gaps exist out there. And of course, as Hannah had spoken to about the model, the DTC model, the service tracking also allows us to understand how well we're, how consistent we are with the guidelines. So what is it that we actually track with respect to services? One of the things, so this is for quite some time, we actually tracked services at drug treatment court on paper. And then after a while, it became clear that we needed to have some kind of a way to aggregate this information and to really understand the amount of work that goes into and the type of work that goes into the client support. So the Calgary Drug Treatment Court, again, has a case management software that they're using. Again, I know people without funding will say, what? So that we've been quite fortunate. But you know, in some ways, let me just say this, that there is a bit of a, you know, chicken or the egg. You need evaluation to get the money, you need money to get the evaluation, right? So if you're able to balance both of those things, then you're kind of in a good place. So we do use that case management software to gather information about actually all significant contacts. So what happened in the contact with the client, and the contact means, you know, contact with case managers, court attendants, treatment groups, employment program. So we track all that to understand the full scope of service. We also track progress through treatment. So this means setting goals. So goal attainment scaling for some of you who knows that terminology. And so we really just we work with clients together. It's a kind of a mutual process to identify goals and then see how to support clients along the accomplishment of those goals and then identify barriers that they have. The other piece, and I've spoken about the importance of being part of the service continuum. Calgary Drug Treatment Court, again, is part of the service continuum, so it's critical to track referrals in and referrals out, and who you're working with and where the gaps are. It's really helps us to understand where we need to strengthen our relationships. For example, just to give you a sense of about 30% of the staff time is allocated to that external work, to the advocacy work. And sometimes that changes, of course, depending on the complexity of the needs. So the third piece, we've talked about clients, we've talked about services, and the third piece is outcomes. So I think we've talked quite a bit in other places about the importance of outcomes, and Hannah had mentioned it too. One of the things I wanted to really emphasize is how outcomes are different from activities or services, right? You could have clients participate in all the services that they need to participate in, but it's quite possible that they might not be successful, right? So that's why we need to understand the service content, but then we also need to understand, well, what actually happens in terms of changes. So that's one thing I wanted to mention here. The other that's really critical one about outcomes is that it's not just successes that we're looking for. And Hannah, you again mentioned that as well, because it's the purpose of really getting a sense of what successes are is primarily for the purposes of your funder, right? Is to help them understand, yeah, you're doing what you say you're going to do, but it doesn't really help you improve your services, right? So from that perspective, it's really important to understand what maybe isn't working and maybe for whom it's not working, right? So you might have a program that works overall and it looks successful, but then when you dig in a little bit, you might see that, again, so we often see in programs, Indigenous communities might not be as successful. And part of that is because service delivery may not be as culturally competent as it needs to be. So one of the specific examples for Calgary Drug Treatment Court was that we've seen that our outcomes weren't as good for younger people, younger men. And so because of that, we modified the program expectation to increase their engagement with supports, both professional and personal. And that really helped move that group forward with respect to outcomes. The other piece to mention about Calgary Drug Treatment Court is that it has established an early intervention stream, and that is because there were some clients who were less complex that did not require the full extent of the service, and in fact, it was counterproductive for them. And so they could stay in the community. They didn't need to stay in the treatment facility and participate in the program in somewhat of a different way, less intensive way, which actually then allowed the program to serve more people and also to cost less money. So what are some of the outcomes that we actually do collect? Again, I do appreciate that people might not be able to do this all, given the resources that they have available for evaluation, but minimally, I would say retention is probably critical to gather. Retention just simply means what percentage of your client group is discharged and what percentage graduate successfully. And also, how long do they stay? Because we know longer term stay actually results in some good, produces some good results. So the other thing that we look at is addiction, relapses, and sobriety. So this is something we don't expect people to have no relapses, right? We know that in fact that there will be relapses. We're not interested in total abstinence, but we're more interested in behavior, honesty, and commitment. So those are some of the other things we're looking at. The health and other health indicators, we actually gather through qualitative interviews and exit interviews. And just to say, the value of qualitative data collection is really important to put in that context to some of the other data. And then finally, we have the employment program that helps people who are, many of them are in poverty, helps them to become more stable and engage with employment, and the CDTC staff actually support people in remaining in employment. So recidivism, we have been fortunate to look at long-term recidivism of our clients and be able to show the impact, which has been pretty successful. And then the cost savings, where we've done the SROI, and people are familiar with that term, social return on investment, where we have demonstrated that there were savings, for example, of over $76 million in the cost of stolen goods of a period of 4 years. So those are just some examples of the types of outcomes we look at. And I know my time is probably coming to the end. And so this is the last slide. One of the things I wanted to mention here is that evaluation is not a one-time exercise, or at least it should not be. It should be integrated within your service delivery. It should be continuous, and it should provide information for ongoing learning. So you could see how you would use evaluation data to design and plan, then you collect data, then you analyze, adapt, you change your programming, and then you redesign and replan, so it's ongoing program changes. And I would just say that again, what really helps to integrate data collection in any agency is actually bringing the data to the staff and having them engage with it and having them understand and speak to what that means to them. So I think I will wrap up here. That'll be the end of my presentation. And the questions are going to be later, as I understand it.
Okay, thanks, Irene. Well, I think we've got all of our questions out there. So Irene's question was, does your program gather data to understand participant outcomes? I'm going to guess, given that the answer to the first question was that people don't have a budget for evaluation, that maybe the answer will be no, or maybe that's an assumption. Anyway, correct me if I'm wrong. But thank you. And so let's move over to Michael. And Michael, I think people did answer your question correctly. And, the ideal time to start an evaluation is at startup, not later. But anyway, over to you, Michael. Thanks.
Thanks, Arla. I appreciate that. Okay, let me move over. Right, so thanks to my colleagues for some excellent presentations. And I look forward to hearing from all of you and receiving some questions later. So all of us have sort of overlapped a little bit. So, but again, we try to, I think, hit the high points because there's some certain things that we would like you as practitioners to come away with. And so I'll probably reiterate some of those points, but hopefully in a slightly different way and maybe some more interesting stories as well. So try to contextualize it and give you some examples. Right, so the ideal time to start evaluating is right away, 2 years and 5 years. But it's funny, and I teach evaluation. So most people, when they think of evaluation, they think of the black box, right? They think, well, is that drug court program, is that working or not working, right? People think of these sort of big ticket types of things, right? Did it work? Didn't it work? But evaluation, of course, has a lot more to offer people than that simple yes, no. Not that that's not an important question and that we shouldn't ask it in different ways, but evaluation can do other things. So, and again, I think we've kind of mixed it up. We don't want to get too technical, right? Because we know that you're practitioners, but you're also smart people. And people, now everyone talks about evidence-based practice. And so there is some technical knowledge that goes with that. And so when we talk about evaluation, people make this distinction of summative and formative evaluation. So summative is associated with sort of more black box types of evaluations after 2 years and 5 years. And then you look at sort of the big ticket outcomes, right? And so most of you, I'm sure, are familiar with things like graduation rates, things like recidivism, and then ideally you can look at things like relapse and improvement in lifestyle. And so formative evaluation is a little bit different. It's concerned more with process, right? And how actually the program is running, and also things in and around implementation, right? Which is, again, is process-based. So again, that's formative is generally thought of more with respect to startup and formation, but formative is also associated with monitoring. And although we have talked about monitoring in the first year, and I want to talk a little bit about the importance as the others have touched on, monitoring is also sort of an ongoing type of thing. Okay. Also, I don't want to totally distinguish monitoring from outcomes, because collecting outcomes ongoing is also important. Certainly I found in my research, and my colleagues have as well. So what is monitoring? Well, monitoring is concerned with implementation. You know, are we implementing what we thought we would? But it's also the practice, if you want to look at the technical definition, ongoing collecting and reporting of data on program activities, products, and outcomes. And that's from Rossi, Lipsy, and Henry, probably three of the best writers on program evaluation. If you're ever interested, there's an American textbook that's worth buying, although McDavid, Hawthorne, and Hughes have a Canadian volume. It's also, I think, quite worthy. Right, so again, you can also look at outcome, but generally with monitoring, right, we're asking the question, right, how are we doing so far, right? And that's a reasonable question. I think the other way also to think about it is, how did we do last year, right? If you're able to do ongoing monitoring. And again, people have talked about funding, but I think arrangements such as Hannah's, where you find academics who and interest them, right? Because drug courts are interesting, right? There's a lot of things going on in drug court. You got these court meetings, you have individuals with significant addiction histories, you have actually some very interesting outcome measures, you have different models of case intervention. So there's a lot of interesting things for researchers to actually look at that can assist you in evaluation and student placements. And we did a lot of research. Part of it was funded for the drug court, but a lot of it we also did with our students. So yeah, so the reason, of course, that we should monitor, especially from the beginning, is because there are resources. Some of your programs are unfunded, but there are still resources being committed to it. And as Hannah alluded to, sometimes actually we put in resources to things that don't work, and sometimes that make things worse. And so it is important, even if we're reallocating resources to run a program, that we monitor and we ask important questions. And of course, 2 years, 5 years, it may already be too late. And of course, if your program's not running, you know, very well, it's unlikely to continue in whatever form it is. Okay, so there's three things that I want to talk about in terms of domains of program monitoring and what's important. The first one is service utilization. The section is organization, and the last one is outcomes. I'm not going to talk very much about that because others have touched on it already, but I do want to talk a little bit about issues around service utilization. So again, we have these target groups that we establish. Is that the group that we're ending up seeing in the drug court? And the other thing is just simply the organization of the program, and is it actually working the way it's supposed to work? We said we were going to do this. Is that actually what's being done? And that seems like a straightforward question to you, but in my experience as an evaluator, that's not what is always done. Yeah, outcomes, sometimes it can be quite preliminary, but it is never too early to start collecting those research pieces. And again, you always want to think about whether the changes that you're seeing are due to the program. And again, that becomes more complex to measure. And I thought Irene gave some interesting examples of how someone might go about doing that. Okay. Oh, right. There's always another picture. Okay, this idea of service utilization, the coverage, and that's successful participation by the target population. And so, here's what's interesting, the Winnipeg Drug Treatment Court, which I think has been a very successful program in many ways. When they originally wanted to start up, they said, people in the advisor group would say, sex trade workers, a lot of them are heavily addicted, and gosh darn it, we need to target a lot of these individuals because, they're being, victimized, and we can help them. And yet when it came time to run the program, nobody really thought that, one of the big incentives, of course, of joining the drug court is you're avoiding these lengthy prison sentences, or even, well, I don't know, 4 or 6 month provincial terms, and often federal terms. But the average sex trade worker was not serving 6 or 9 months. They were getting time in custody. They were maybe getting 30 days. So as a referral source, that was not happening. The other thing they said they would do, and a lot of drug courts do it, was they were saying, we're not taking any violent offenders. And yet, when defense counsel pushed and said, well, this looks like a robbery, but basically the person was wrestling with their mother and yanked their purse and ran away. And it's not the most serious, robbery that we've ever seen. And of course, if your drug court is actually going to reduce the use of custody, you need to take people who've committed, serious offenses. So during the first year, there was a shift, right? And in our monitoring, we talked about, the reality that, you could take violent offenders without unnecessary use, right? And sometimes you're doing that based on what you've seen in the program, but sometimes even if you haven't seen the program for that lengthy a period of time, if you're familiar with the literature, right, you can actually look and say, well, you don't really, increase risk, you don't increase it that much. The other thing, of course, you're interested in is do you actually see addicts in the program? And as Irene was saying, it's important to know who's in the program. So the retention rates sometimes for the Winnipeg Drug Treatment Court aren't great, but they take serious offenders. And we were able to chart that for them. You get these drug courts in the US that claim they have a 60 to 70% graduation rate, and you find out they're taking in people for possession of marijuana, and the drive while impaired courts that take people without really any sort of serious backgrounds. So all that information is important to prove the viability of the program, and really, I think to make sure that you're expending public funds on people who really need that sort of help. Okay, and I've talked about the initial period, but also in terms of the ongoing, and Irene was talking about that. And that is, we would report the profile and background. And so when we look at referral, right, like we like to see sort of a balanced referral. So when 60 to 70% of our provincial jail admissions are Indigenous individuals, you'd like to see, hey, let's make sure that our diversion programs have a high proportion of Indigenous people. And so, although it becomes difficult depending on the severity of the individual and the background, we did actually push for more inclusion of Indigenous referrals as a result of our tracking things each year. And again, in coverage, we looked at the efficiency of referral, and we went away from a more elaborate addictions assessment. And there's nothing wrong with that, but they were taking like 2 months for people who are sitting in custody, which is not an efficient way to do things. Right, and so again, if you've done a needs assessment, and most people haven't, or if they have, it's usually not that well done. But if you have a great needs assessment, you know who you're going to target. It's pretty easy to compare, and you can see in your first year if you're reaching that population. Otherwise, program records is how we've done it. Most people do it, looking at the individuals who are in the program and whether they fit their profile of addicted individuals who need the service. Sometimes you will do surveys, observation within the program. Okay, otherwise monitoring organizational functions. And so, people are shooting the arrows or they're hitting the target. It's a good question. And sometimes you have the implementation itself just doesn't work. And I've done evaluations on programs, and I hate to say this to people who would love to have a little bit more funding for their programs, but I've seen people get money for programs, and it seems to happen more often in crime prevention, and they end up not being able to do what they originally said they were going to. So they did other things, right? Like, so somebody was going to do gang sessions for parents, and they're going to run these groups, and then they found out that the parents didn't want to meet, or that it was hard to get them to come to meet. So they ended up doing presentations in schools that had nothing really to do with the original. Another one, they were supposed to coordinate gang prevention programs, and apparently that didn't take much time, and they were trying to do social work with different people. So sometimes you have a program that's never actually delivered. And sometimes the way you implement the program can end up making the program incomplete. So we had an AIDS information program, idea being to distribute these pamphlets to inmates when they came in, and giving us some information about AIDS and how to protect themselves when they came in. Kind of interesting with COVID, sort of hygiene is important. But we found that all those AIDS pamphlets were thrown in the wastebasket or dropped on the floor. And we couldn't figure out why was that happening. And gosh darn it, they're supposed to read those things. Well, the nurse was giving it to them during the admission process, and they didn't want to walk out of the nurse's room holding this AIDS pamphlet and having all the other inmates looking at it. So sometimes the way you implement a program can end up impacting it. Inmates just didn't want to read it to public space. Yeah, so again, I'm going to reiterate what Hannah and Irene have touched on. If you get nothing else out of this, well, one of the things why it's good to get someone involved early on as an evaluator or researcher is the data recording. Because what we found, and what I found in other work that I've done, is people record all kinds of stuff. Staff and social, they love to write all kinds of things, but often they write things that aren't useful. I mean, arguably they're useful to them. They'll write these long, I had an interview with Mary today and she was upset and we talked, and that's great, right? But a page of that may not translate into anything that I can quantify or summarize for researchers at the, or for the stakeholders, funders at the end of the year. So I actually look at things sometimes and say, you guys don't need to record all that. What you need to record is this, this, and this, and you can come up with a shorthand, and you don't need a fancy computer program. You can create a spreadsheet in Excel that can be very easy to update, and actually it's very easy then to give to researchers to use. Yeah, talking about, so again, you can have too much research. When we started, the feds who funded a lot of drug courts initially had this huge database, and it was, I thought, whoa, crap, why would you, I didn't know why they wanted all that data. Well, I shouldn't say I didn't know why. I mean, if you get enough people in a room long enough, they'll say, and why don't we ask this? And why don't... But what happened was people never filled it out, or they didn't fill it out completely. It would be inconsistent. And so sometimes I thought the important things were not being recorded. So, yeah, so I think that evaluators can sometimes help you say, you should record these, and these things. And that way we won't lose the data or have to spend a lot of time and money trying to find that data later. Yeah, United States, trying to discourage traffic stops of minorities. They had the police fill out these cards in one jurisdiction, and they already had a bunch of data that they were collecting, and they just didn't do it, right? Yeah, so again, in our first year, we found there was a lot of data that wasn't being collected. And so we identified a number of things that people could improve on, and they did. Yeah, so again, you need some quantitative data. We collect qualitative data as well. As Irene was talking, we would do exit or follow-up interviews, graduate interviews, and not enough with dropouts, I think, and that's something we'd like to improve on in future work if we do that. So, but in the end, you need some quantitative data. Yeah, just the other thing I guess I would mention that we have done these ongoing monitoring exercises with the WDTC, and then they actually stopped funding that around 2015-16. But we would do something different, right? Like give you something for your money. So we did a comparison study with equivalent probationers 1 year. Another year, they had our residents that was funded through CMHC, and we did an assessment of that, right? So an ongoing relationship with researchers, sometimes in addition to sort of the good ongoing data, you can get some different things also delivered. Okay, otherwise, I just put in the plea as a social science and an evaluator is evidence-based practice. Everyone thinks that's a great thing. And everyone says, we know what works, or, we have research. And so people, need to contribute to that. So I hope that some of you, when you come away from this, that you, of course, support evaluation, but also think about the utility of sort of these ongoing relationships, right, to help build up our evidence-based practice. So again, you need good data, right? You want to see that program implemented the way it was intended originally, and yeah, adjustments ongoing, that they're logical and end up being effective. Okay, and that's it for me. Thank you.
Okay, thanks, Michael. Great. Well, I'll just share a comment, a brief comment from my perspective. I really appreciated all of your presentations today. I have to say, as a manager in a DTC program, all of what you're talking about is exactly what we experience in our program. That it's so helpful. It's so helpful in problem solving. It's so helpful in really understanding what you're dealing with, who you're serving, how you're spending your time, and what the impact of that is. And so as a manager, it is undoubtedly one of the most important tools I've ever had, is the ability to get that kind of information, because we are collecting that data and we have somebody supporting our evaluation, to be able to understand, answer important questions, and problem solve. And also, maybe particular to a drug treatment court, it also helps with collaborative problem solving and decision making. So our multidisciplinary team, multidisciplinary partners, all also like to understand what, who are we serving, what's going on, being able to provide some amount of data to be able to describe that, and having it align with what you're seeing builds a lot of trust and openness in communication and planning. So it's certainly been very, very helpful in our program, and I think what you had to say today was very helpful. So wondering if any of our attendees have any questions at this point. If you do, just put them in the chat. Maybe one question, since we seem to have people who maybe don't have a budget for evaluation, and maybe are looking to start up or improve on evaluation. One question I would ask would be, evaluation, all of that can seem a little bit overwhelming to imagine how you'd implement. So I'm wondering about simple techniques or strategies that you would recommend to either get started or to advance, from more of a beginning place, right? I don't have a full out evaluation. What are simple things that can be used? To start that, I would say, I know Irene mentioned that we have a database, and in Calgary, we do have a database, but if you look at the databases that are available, some of them can cost, $30,000 or more, and they seem like a prohibitive cost, but we, had one customized. It could easily have been achieved with a one-time grant. There are things that can be done, and when you look at the first layer, it might seem prohibitive, but there are some things that can be done that are simpler and less costly. So anyway, over to our speakers. What strategies are there to get started? Or Hannah?
Well, I think the first strategy is always to get over the. I think drug courts are unique, and they sort of face some challenges, right? There may be no buy-in by some members in your court building, but then there's the people who very much are part of that drug treatment court and believe that it's effective and it worked. So I think part of it is, the start of it is just talking to it. It's not that it costs, evaluation costs money. Start talking about how it saves money and how it makes money. I think that's part of it. So change change the people that you're talking to, change their minds. The second thing I would say, if you have no funding at all, and you don't have a university partner like me, who is part of a system, or like these two who have clearly regular funding and have great infrastructure, is actually just start to take stock of what you're collecting. So go around the table at your steering committee and say, what data do you collect, right? Because then you could compare it to some of the other drug courts. I'm sure that everybody's all that talking. I know Irene and Mike would be happy to talk to you about the things that they collect. And then maybe have a discussion about what you would like to collect, and let's just see if everybody's going to collect it. And then sort of, if you build it, they will come. And then hopefully once you're invested in the collecting, somebody might actually want to look at it. And I would recommend ultimately, such as we have here, Michael at the University of Winnipeg, who's separate from the court, and Irene, who works as a third party evaluator, is great because of all of the HIPAA and FIPA. So you have to be aware of all of that. And so, you know, getting funding for that third party, and maybe they can talk about how they're funded, because maybe they can give you ideas of maybe how they started to get funded and so on. So that's really my take on it. Thanks.
Any other comments? Michael?
Yeah, I would say Excel is your friend. And so I'd say for those of you who don't have any money but are interested in evaluating and want to start collecting some data yourself, yeah, Excel is your friend. And so a lot of it is just, you know, basic demographic data, right? And a lot of this information is available on your file, but it's a lot easier if you end up, you know, securing a researcher in the future, or even if you want to start doing some stuff yourself, right? So you just have a file number, the name, the date they entered the program, their living arrangements, marital status, whether they were employed or unemployed, education level, the offense or offenses, and then things like drug of choice, first drug of choice, second drug of choice. Just trying to think. Yeah, because all this stuff, I'm sure that you collect it in one way, shape, or form, but it's nice data to have for annual reports. And to be honest, Winnipeg, rather than us root through the files every year, they used to just give us an Excel sheet where they were doing that. They were, not all the information was on there, but a lot of it was. Yeah, I mean, I think like some of the stuff, like recidivism, I mean, you really need to check, you know, different databases. And even for us, right, in Alberta or in Manitoba, we went through provincial corrections and court databases for recidivism. But one year we actually, because it cost money, we got some extra funding, or we took some of our funding and we just paid for CPIC records. And there was one offense outside of Manitoba. They like to commit crimes close to home, I guess. There was one reoffense, and our reoffense rate is very low, by the way, for graduates drug court. And that was out in Calgary. And we actually knew about that because they'd heard through the grapevine the person had gotten into trouble. So anyway, yeah, you can record a lot of data, and it'll be relatively easy for people to access and convert into an SPSS or other sort of file. You too can be a researcher. And if any of you are interested in doing something like that, want me to put something together for you, just email me and I'll get something.
Irene, did you want to add something?
Yeah, actually, yes, I do. But I think there's a question in the chat for Michael. Did you want to do that first?
Sure, Michael, there's a question here. Who was preparing those spreadsheets in Winnipeg that were sent over to you?
Oh, well, I'm not sure. I got it from the administrator, so maybe it was him, maybe not. Yeah. Yeah, I mean, I guess there's different ways to do it. I mean, some of you already may have automated systems for admitting people, so I don't, but again, it's just a lot of that stuff doesn't take very long to compile for new admission, unless you have, you know, 50 or 60 people coming in a week. It wouldn't, I don't think it would take you that long to put something in. And a lot of that, I mean, you know what, it's on the file already, or should be. I would think that people would have that information at hand.
Okay, Irene.
Yeah, I think everything that Hannah and Michael had said, just right on. Some really awesome suggestions about how to start things. And I was just going to comment, also add about the critical importance of the leadership around evaluation. So if you as a leader in the organization are not fully 100% committed to the value of evaluation and wanting to do it, it will not happen. It's just pretty simple. So I think that's really the first step. And if people need to get there, you know, there's, I mean, lots of expertise here and lots of kind of reading or conferences one can go to really get to the depth of why it's important for your organization to do it. There's a lot of really good reasons, but that's the first thing. If you have leadership commitment, then everything else follows. So what I would then say is it's the engaging the staff as well in conversation about evaluation. And that means starting to, I think that Hannah said this too, but starting to talk about what is it, or maybe Michael, what is it that we want to accomplish? You know, why are we doing what we're doing? What are we seeking to see? What kind of, you know, to start people kind of meaningfully engage with their work. And I think a lot of staff, if they're able to do that, then they feel a lot more engaged with their work, and it's not just same old every day. So I think that's the beginning step. And in some ways, if there's leadership and the staff are engaged, then you can have conversations with your funder about, look, this is where we are. We're already moving in that direction and we need some support. And I think I would also say that it might sometimes sound like evaluation is a complex undertaking and a really big, complicated thing. But just like Michael was saying, Excel can address your needs, you know, and I think just doing things in small increments can also work. Right? Maybe you just start by you know, tracking your intake information, or just tracking some contact information. Right? Maybe you don't get to outcomes, but you can go little by little to the full comprehensive evaluation. And I think if you engage with the funders through this process, you know, in kind of relationship building with them and helping them understand why you're doing what you're doing, and that you're committed to this independent of whether or not there's money, right? Because that's really critical. And then they can see that you are interested in doing this, and you are very likely to have an uptake on this. So I would say, yeah, that would be my comment, is that it starts at the top. There needs to be commitment at the top. And then it doesn't have to be a big complicated undertaking. You can do it a little piece at a time.
Okay, thanks everybody. Okay, I don't see any more questions in the chat. So I think we're, unless anyone on our of our panelists wants to add a final comment, I think we're about ready to close. And maybe is there a final comment from anyone, or no?
If I could add, thank you so much to all four of you for enlightening us on the techniques and challenges and successes you've had with your evaluations. I have to say, for me, even just hearing the title evaluation and monitoring, it's very overwhelming. So you really were able to break it down and make it seem like, I believe, Irene, you were just saying, do it in small steps. So it just naturally happens organically. And it's certainly something that, as one of the unfunded programs here in Brampton, we could take with us. So really valuable lessons and insight. Thank you so much for your time today. I really do appreciate it. And I'm sure that myself and other people who have been watching today will reach out as you've offered for some help. So thank you so much. And I hope you enjoy the rest of your day and stay well.
Thanks, everybody. Bye.
All right, bye, thank you. So we're taking break a little bit early today. I don't think our next panelists will be with us until 2:45. So we've got a longer break, which is totally fine. Well, I guess we'll see you back at 2:45. All right, thanks everyone.
Jen. Jennifer Graham.
Hello?
Hey, you're sharing your screen.
Oh, all of it?
Yeah.
Oh, thanks. How do I do that? Stop that.
Stop share. There you go.
Thank you. How? Okay. All right.
We're good.
Okay, thanks. Okay, thanks.
No worries. Because you were on scope.
Bye.
Anyone see that?
Yeah, yeah. No, yeah, thanks. Oops. Okay, I'll just move that to my other screen then. Okay, thanks. Hello again, everyone, and welcome back. Our next panel we have here with us will be discussing harm reduction and the drug treatment court practitioner. That's the title of the panel. We've got two amazing presenters here with us today. The first is Alejandra Garcia. She is a senior program manager for the Center of Court Innovation's National Technical Assistance Department, leading and delivering a wide range of on-site and remote technical assistance projects, including drug treatment court evaluations, opioid court implementation, statewide strategic plans, and training events. Previously, she worked as the program associate and social work intern for the center's Training Institute, where she co-created and implemented the strategic plan for its inaugural year, as well as collaborating with departments across the center to develop original training content. She previously interned with the New York Legal Assistance Group's Legal Health Department and has worked in a variety of roles in the area of youth development. She received her MSW from the Silver School of Social Work at NYU and her BA in Sociology and Psychology from Columbia University. We've also got with us David Lucas, who is a therapist and social work educator specializing in the areas of addiction counseling, court supervised treatment, and problem-solving justice. As senior clinical advisor at the Center for Court Innovation, he consults nationally with legal system practitioners, that being judges, attorneys, and law enforcement, and clinical teams on overdose prevention, health equity, and person-centered care. Previously, he was an addiction therapist and drug court clinical lead at the Center for Addiction and Mental Health, providing support for formerly incarcerated and unstably housed patients. During those years, Dave also served as an adjunct professor at the University of Toronto, course director at York University School of Social Work, and presented internationally on drug policy and best practices for addiction care in the legal context. Before relocating to New York in 2018, he spent his last years in Toronto moonlighting at the Moss Park overdose prevention site. So Dave and Alejandra, thank you so much for coming to speak with us today. We really appreciate your time and very much look forward to hearing what you have to say. So I'll turn it over to you.
Great, thank you. Just give me one moment to share our screen. Okay. How's that, Dave? Okay, great. Thanks for bearing with us through that. So hi, everyone. Thanks so much for having us. We're here today to talk with you about bridging the gap between drug courts and harm reduction. Many thanks to Jennifer and to Justice Barnes for inviting us to be with you today. We're really excited, and we hope that you get some grounded and practical ideas to take back with you after the presentation. Okay. So today what we're going to cover over the next hour is first the origin and evolution of harm reduction as a movement, as well as its principles, practices, and scope. And this will ground us in the presentation so that we're all working from the same understanding. And then we'll talk about the intersection between harm reduction and drug courts, covering the overlap and tension we see between them. And then we'll walk through 5 key intervention points of the treatment court lifecycle, beginning with identification and going through graduation or termination. And at each step, we'll investigate how we can incorporate harm reduction by offering our own critical reflections, posing questions for you to take back to your teams, and then we'll provide a look at some opportunities for change at each intervention point. Okay. But before we get started, we want to tell you briefly about ourselves and where we're coming from. So the Center for Court Innovation is a justice reform nonprofit that's primarily based in New York City. The Center for Court Innovation works to achieve justice and equity, create safe, healthy, and thriving communities, and ultimately transform justice systems. So we do that in 3 key ways. We've created dozens of our own operating programs to test new ideas. We perform original research to determine what works and what doesn't. And then we provide technical assistance to justice reformers around the world. And Dave and I are here representing our technical assistance department, in which we do, just like Jennifer said, a range of strategic planning and training, producing publications. So we have a national perspective on what's happening with drug courts in the United States. And so you'll hear us speak from that national perspective throughout this talk. Okay, and so we just had our bios read, so I won't say too much other than just to reintroduce myself. Alejandra Garcia, I go by AJ, and what you see here is a picture of my hometown of San Francisco, California, where I was born and raised. And Dave, if you want to say hi.
Yes, thanks AJ, and hello and good afternoon to everyone. As AJ mentioned, we're very honored to have this opportunity to speak with this esteemed audience today. I just want to send out an extra special hello to a few of my Toronto friends I see on the line. You probably thought you got rid of me, but here I am. Anyways, my name is Dave Lucas, and I'm a clinical advisor also at the Center for Court Innovation, as mentioned. I live in New York City as well, but I'm beaming in today from the very small, very cold town of Gimli, Manitoba, where I've decided to spend my winters for some reason. But apart from that, I'm just really excited to get this chance to talk about this intersection, drug courts and harm reductions. For those of you who know me, it's a very near and dear topic for me. So really excited for this opportunity. AJ.
Okay, so to begin, we wanted to tell you a bit about our motivation for this presentation and a bit about the material that we're working from. So this year, Dave and I published the paper that you see here on the right called Bridging the Gap, a Practitioner's Guide to Harm Reduction in Drug Courts. And the paper represents an effort to have drug court practitioners reflect on standard drug court practices through the vantage point of harm reduction. Now, aside from what Dave and I have learned through our work around the country, this project was also motivated by the moment. So we were and still are in the midst of several overlapping and unrelenting health crises, namely COVID-19 and the overdose crisis. We're also seeing an increase in prison deaths in some parts of the United States. And what these crises have in common is that they all show disparate outcomes, with Black people and people of color dying at higher rates. So the last year and a half has given rise to renewed conversations about institutional racism, healthcare, and criminal justice reform, altogether making the moment really ripe for reflection and tough questions about drug courts as well. So those are some of the motivations for writing this paper and presenting this material. And so now I'm going to hand it over to Dave, who's going to walk us through an introduction to harm reduction.
Great, thanks AJ. Okay, so I certainly can't do justice to every important harm reduction flashpoint throughout history in a few minutes, but I do want to highlight some of the lineage, just so that we do have a sense of where we've been and how we got here today. So for most people, the harm reduction movement, at least in the US, begins in the 1980s in response to the HIV and AIDS epidemic. We see the first needle exchange efforts take hold as activists attempt to impede the spread of disease among injection drug users. Giving out sterile needles was illegal. And so many of the people doing this work were arrested, and often by 1988, however, there were at least 185 syringe programs around the country, but again, they were still mostly unsanctioned, unfunded, and street-level operations. At this point, they were evidence-based, but largely objected to on moral grounds and still fairly politically unpopular. Prior to the 1980s, and perhaps depending on how one defines harm reduction, there are a few other moments worth highlighting. The first is the discovery of methadone as a treatment for opioid addiction, and eventually the establishment of the first methadone program in the early 70s. Methadone had been developed in Germany during the Second World War, but its capacity to treat heroin addiction wasn't discovered in the US until the 60s. Interestingly, it was Nixon who established the first federal methadone program in the 70s, and this was in response to a rise in heroin and painkiller use in the US, particularly among soldiers returning from Vietnam. As a side note, Nixon is mostly known for his anti-drug crusades, but to his credit, he did understand the importance of improving access to treatment. In fact, his crusades were more treatment focused than Reagan or even Clinton years later. So That's surprising to a lot of people. What's most notable here in terms of harm reduction, however, is that this is the first time that we hear the moral hazard critiques of substitution therapies. That is the claim that methadone treatment may simply exchange one addiction for another. But in contrast to these perspectives, there was also a growing call to decriminalize drugs in the 70s. In fact, Jimmy Carter's presidential platform included the decriminalization of at least cannabis. While these reforms never came to fruition, at least not until recently, it is notable that many of the discussions that we're having today, debate around the science and morality of methadone and needle exchange or reforming drug policy, we were having them 50 years ago. So the room has been split on these issues for quite some time. In the 1990s, at the height of drug war policing, we see the first naloxone distribution efforts take hold in Chicago, courtesy of Dan Bigg and others. In the 90s, as raves made their way from Europe to North America, so did some really important drug testing practices. But fast forward today, and we're well into the third wave of the overdose crisis, and the harm reduction movement is still fighting for political, cultural, and legal legitimacy. In recent years, we've seen the establishment of Good Samaritan laws, better access to naloxone, and we have degrees of decriminalization in parts of the US and Canada. But then you still can get arrested in other parts of the US for having sterile syringes on you. You can even get arrested for possession after surviving an overdose because technically you have illegal drugs in your system. So all to say, for every step forward, there's often one or two steps back. Notably this year, the White House has set harm reduction as a funding and research priority, but it remains to be seen what that will include and not include. For example, the main reason that the US doesn't federally support supervised consumption sites is because of Biden-led drug policies from the past. So we'll see if those change. Okay. So just to quickly draw some borders around what harm reduction is and what it isn't, because the concept can get a bit murky and is prone to misconceptions. So I'm just going to run through this quickly. The most plain definition, harm reduction is focused on reducing the harms associated with drug use, sexual activity, and other behaviors that have always existed, always will, and always will carry some kind of risk. Harm reduction treats these activities as not inherently good or bad, and instead is focused on providing the information, supplies, and environments needed to engage in these things safely. It is not pro-drugs or indifferent to the real harms of addiction. It is just a very practical and research-backed set of practices aimed at improving the immediate safety for both individual and community. It can include everything from counseling, medical care, service referrals, education, and syringe disposal boxes in public bathrooms. Harm reduction is also traditionally peer-driven, which can help to make these spaces feel more inclusive, inviting, and low barrier than traditional healthcare or social service settings. Harm reduction is not technocratic, but rather a dynamic and evolving movement. It involves advocacy and activism, calls for better housing and healthcare accessibility, legal protections for marginalized groups, economic justice, and racial equity. So you can see it really encompasses a lot. And in this way, harm reduction has micro, meso, and macro aims, or in other words, very immediate and more long-term transformative goals. Harm reduction wants to enhance individual well-being, but also demand that our public health institutions become more accessible and responsive, and that our drug policies more humane and less punitive. And so just to reiterate, harm reduction is not about enabling addiction, despite some of the common kind of representations we see. It's about enabling survival and dignity as one works towards making changes in their life. It is also not anti-abstinence, which I think is really important to underscore here. It understands that for some people, abstinence is the clearest pathway to improved health, safety, and quality of life. But it also understands that for others, these improvements can be achieved through change or a reduction in one's use. While community-based harm reduction typically supports people who are actively using, the philosophy does not dissuade people from pursuing abstinence and is more so a response to the gaps and the harms that are generated by abstinence-only services. All to say, harm reduction is only opposed to abstinence when it contributes to social exclusion, but not as an individual health goal. Similarly, harm reduction is also not anti-treatment, but it does stress the importance of continuing to support people who are not interested in treatment. Harm reduction is also not indifferent to drug-related crime. In fact, a primary aim of harm reduction is to prevent people from becoming more justice involved than they already are. And lastly, we sometimes hear from skeptics that harm reductionists meet people where they're at, but then they just leave them there. And again, I think this idea comes from the belief that because harm reduction isn't directive, in other words, it doesn't tell people what to do, that it isn't directional. And so hopefully AJ and I can help clear some of that up today as we move through these different practices. Okay, so just quickly, earlier on, I listed racial equity as a harm reduction priority, but I think it's important to zoom in on this to help us understand why racial equity has become such a central focus of harm reduction. So what we have on the slide here is a very oversimplified timeline of key shifts in drug policy and the groups that were impacted the most. It's certainly not an exhaustive list, but these are arguably the most critical junctures in American, at least in American prohibitionist policy. Canadian policy does map onto this pretty closely too. Now, what hasn't always been talked about, even in the early harm reduction circles, but we have a deeper recognition of today, is that throughout history, every time a new campaign against a particular drug was being waged, or, you know, every time that there was a new campaign against a particular drug, there was also a non-white drug user being targeted at much higher rates than their white counterpart. And that is in spite of the fact that white people have always used drugs at steadily higher rates than people of color. Now, each one of these flashpoints is a complex historical moment unto itself, and I don't want to oversimplify, but if we take all of these things together over 2 centuries, we've learned that drug prohibitions have always served 2 functions. One, to try and control the moral and physical health of society in general, and 2, to help manage or restrict one or more marginalized groups within that society. Intentional or not, that's been the outcome. Now, favoring tight drug laws doesn't necessarily mean you're also in favor of racialized application of the law. However, we need to acknowledge that at every single policy turn on this list, communities of color have been harmed, policed, and jailed the most. We have no data to the contrary, so we can no longer call that kind of historical pattern an accident. And it's this reality that really undergirds the harm reduction call for major drug policy reform, especially the decriminalization and decarceration of drug users. One last quick point here, you'll note that 3 of the shifts that we might consider as being more positive are highlighted in orange. We have the end of alcohol prohibition, advent of drug courts, and the phrase that we hear all the time these days that society cannot arrest its way out of the overdose crisis. And I wish we could enjoy these developments a bit more, but even these shifts tell the same story. The end of prohibition applied only to white Americans. Drug courts have disproportionately accepted and graduated more white people. And then, of course, the current overdose crisis has recentered treatment as a more sensible response than jail, largely because of whiter communities being impacted in those first and second waves. This, of course, being in stark contrast to the much glamorized police responses we saw in the crack epidemic. Next slide. Thank you. So the last bit of history I want to draw on is this drug court timeline. And I really want to just say here that it's important that we don't view our field as unchanging or unchangeable. For a long time, drug courts didn't have its own research base or a set of best practices to adhere to. Many drug courts didn't allow the use of addiction medication. And only recently as the field started to uncover the deep racial disparities reproduced in the problem-solving courts. All to say, drug courts have had to evolve since day one, and they need to keep evolving, especially as we face new, or in some cases, recurring public health crises. So that's kind of the big table setting for today's conversation. And AJ, I'll pass it on to you.
Okay, great. So now we'll think about how harm reduction and drug courts intersect and think about where we might bridge the gap between them. So first, we want to extend our respect to those of you out there who are already doing this work by asking yourselves and your teams hard questions and trying new practices. Our goal is to honor that work that's already happening as much as possible as we try and wedge these 2 worlds together. So let's talk about some of the overlap and the tensions. So first off, drug court practitioners and harm reductionists have a shared interest in improving public safety, improving public health and community safety. Broadly speaking, practitioners from both worlds see treatment as more effective than jail. Both paradigms place value on addressing a person's key social health determinants. Both have had challenges achieving racially equitable outcomes, and both worlds are dealing with the same service gaps and quality issues. But obviously there are some key differences in how the two models approach the goal of reducing drug-related harm. Coerced treatment is antithetical to harm reduction, but of course is central to the drug court model. Abstinence is just one possible pathway to a better life for harm reductionists, whereas it is it's typically priority number one for drug courts. Drug testing participants to confirm honesty or sanctioning people for recurrences of use. Again, these are core practices in drug courts and are non-starters in the realm of harm reduction. All to say that it's not easy to reconcile these two worlds, but we think there's a way to do it. And you'll see as we go through, we had to sometimes get creative and stretch our definitions in a few places. So we want to offer here some questions to keep front of mind for the rest of our presentation. And these are key overarching questions that we think will help ground us as we go through. So these are, how do our personal and societal beliefs and attitudes about drug use inform how we think about drug users? And how do those same personal and societal beliefs and attitudes inform our drug court practices? So we're proposing that these questions are a key starting place for this conversation. All right, so now we'll transition to the bulk of our presentation, which will be an explication of 5 key treatment court intervention points. For each one, we'll offer our own critical reflections on the practice, answering the question, where are we at with current practices? We'll then pose questions for drug court teams to discuss, which get at answering what steps might we take to achieve change. And then we'll present some opportunities for change that can make our work feel more transformative. And we'll cover identification and assessment, treatment planning and engagement, supervision, case management, and graduation and termination. And then I just want to note that you'll see in each of our slides some hashtags at the bottom, and those correspond to sections in our paper, Bridging the Gap. So those blue hashtags at the bottom. So we'll begin with identification and assessment. And with identification, what we're talking about is knowing our target population and effectively engaging them in our programs. And the importance of universal screening and serving high-risk, high-need participants is well established in drug court literature. So what we want to highlight here is that in the last few years, the field has recognized that treatment courts have been disproportionately serving white people. More white people are admitted, retained, and graduated than people of color, and we have the data to show that. And while that's troubling, we can understand that it's not surprising, right? It's merely an extension of what Dave was just talking about, the historically disparate outcomes that we see when it comes to policing, sentencing, and how drug treatment services are offered. But the good news is that drug courts are well positioned to address this issue if we take the necessary steps. And a lot of this could be attributed to issues of perhaps implicit bias or gatekeeping, but we can't really know the source of the disparities if we're not looking for them. So we have to actively investigate this issue in our courts in order to address it. Who makes decisions around screening? What tools are they using? How is criminal history factored into decision-making? Are the demographics of our jail population proportionate to our treatment court population? So these are some critical questions worth asking. Okay, and for the next step, assessment. So assessment represents a really key opportunity to build trust and rapport between the person who's conducting the assessment and the participant. And we want to keep in mind here that it's the participant's first time meeting us, right? And as we know, they might have a fraught history with the healthcare or criminal justice fields, so they might be rightfully cautious with the information that they share. Assessments can be long and intrusive and ask someone to think about some of the most private parts of their life. So we want to be mindful that this experience has the potential, if not done carefully, to re-traumatize our clients and force them to share things that they don't yet feel ready or comfortable to share with us. What's more is that they might not know how to talk about their situation yet, which can often be read as withholding information or dishonesty. But we want to understand how different folks might be at different levels of understanding, and how holding on to someone's story can be a way to hold on to your power and safety and protect yourself, especially if you've been burned in the past by the systems that we represent. So in these first few interactions with participants, we want to keep in mind that in the long run, engagement, having any kind of conversation with participants that lets them know that we're here for them as a resource, that we're willing to work to build trust, is more important than the actual information that's gathered. And that's the key here, is showing the participant that you're here for them when they're ready to share, and that you have the patience and the understanding and the lack of judgment to handle that story. We also have here a key opportunity to ask upfront about a person's overdose history, and when indicated, to link them to naloxone or addiction medicine within hours of arrest to try and mitigate that overdose risk. And this is a really critical advancement in the field that we've seen. And so courts should continue to screen for overdose risk to the best of their ability. We also want to keep in mind the importance of holistic assessment that accounts for all of the various protective factors that a person brings with them. How have they navigated and survived the challenges they faced? And how can we tease out and uplift those strengths? So we want to make sure that our assessments and our reports take into account the broad range of biopsychosocial needs and strengths. Okay, so we've covered the need for us to examine our identification process and the importance of our assessment process to take into account trauma and overdose risk and become more strengths-based. And the questions that we propose that drug court teams take back with them to consider are, do we have the data when it comes to enrollment and racial disparities, and what is it telling us? Could our screening process be more inclusive? How can we make our assessment process more strengths-based and our staff trained to do so? How is trauma handled? Are participants empowered to not disclose certain information? In other words, do they know that they don't have to disclose their trauma upfront, and how is that communicated? And are we screening for overdose risk and discussing safety planning around using? And so then just some opportunities for change, and these kind of mirror those questions. So the first is that the demographics of your drug court participants match your jail population. And first interactions with participants are trauma informed and focused on immediate risks like risk of overdose. Recognize and center existing protective factors, skills, and survivorship when it comes to assessment, and focus on engagement over information gathering. And with that, I'll pass back to Dave.
Great, thank you. Okay, so the next intervention point we have is treatment planning and engagement. And this is a big one because everything really does flow from the decisions that we make here. Now, through a harm reduction lens, the recommendation is unequivocal. We want this aspect of the work to truly feel client-driven. That means treatment plans are developed and adjusted collaboratively with a whole lot of healthy back and forth about what the goals are and how to measure success, with the client voice at the center of that. And the aim here is to find alignment between us and the participant. We don't want to just, get their acquiescence. We don't want them to sit there passively and just nodding their head. We want to hear what's worked for them in the past and what's felt safe for them in the past. And that's also because harm reduction sees people as credible messengers when it comes to all things that work in their life. And so part of that is even understanding why drug use has brought them comfort and safety. So the more we understand about that, the more we'll understand what a good treatment fit is. We also, as AJ alluded to earlier, when it comes to trying to, understand better the things that clients are not as quick to disclose, we want to avoid kind of those instincts that say, this person is not in denial, or they're not being honest with me, or they're not thinking clearly, or we know what's best. So client-driven treatment planning really means that we're starting from a place of trusting our clients, even if we're only getting part of the story. They actually have a good reason to not give us the full story in most cases. But that said, we also know that collaborative treatment planning is, even in theory, is not easy to pull off. Disagreement about what could help someone tension between what someone wants versus what they need, the normal fears and reservations people have when considering different treatment options, even in voluntary circumstances. Clinicians wanting to feel like they're doing everything possible to help someone, even if it goes against what the person wants or what the assessment outcomes tell us. It's especially easy to have the impulse to overtreat in the midst of an overdose crisis as well. No one wants to think that they're not doing all that they can. So you take all of those very real and understandable tensions, you put this in the drug court context and everything gets pressurized. Participants are up against it. The court basically has, in most cases, all of the leverage. Participants are facing legal consequences, whether they're brand new in the program or they've been around for a minute. And so the treatment plan is being devised with the client in the room. But if you're the client, it's quite clear that it's in your best interest to do what the court says. You want the judge or the prosecutor or maybe someone else who is skeptical about you joining the program, you want them happy. So sure, you'll do a 6-month inpatient even though they don't accept methadone. You'll do that Salvation Army or a strict AA program even if you're not religious. Whatever they want, as long as you're compliant, in your mind, you won't go to jail. Problem is, this is exactly what ends up producing some of the greatest harms in the field. Overtreating, mistreating, referring to poorly trained or culturally unsafe providers because that's what's available. This is ultimately what makes people with addictions fear, avoid, or reject treatment. And yes, it's true that many people do get through treatment after being resistant at first, but that doesn't negate the risks associated with this practice. So bottom line, hastily assembled treatment plans, especially those without the client buy-in, lead to higher rates of treatment failure, and early discharges from treatment are associated with higher rates of relapse, recidivism, and even overdose. Shoddy treatment planning also leaves an imprint on people that treatment isn't for them and it doesn't work, which of course we want to avoid at all costs. Similarly, we need to remember that treatment breakdowns are to be expected. They're very normal. Ask anyone or most people in sustained recovery how many tries it took them. The research says the same. It takes most people 5 attempts, if not more. So even if our referral was a good one, we had their buy-in, the stars aligned with bed availability, sometimes treatment just falls apart. And while this can be disappointing or even frustrating, the most important thing to do here is to focus on reestablishing safety and connection with the client. If they fear judgment or punishment, or worse yet, jail upon their return to court, what are they going to do? They're going to run, and we can't really blame them. So again, we need to take these types of challenges in stride and understand that they're very much part of the process. We want to message that to the participants too, that we still care, we are still invested in you, even if things are not moving in a linear way. And that's harm reduction, but that's also just everything we know to be true in the field of substance use and recovery as well. So there are some other things that we can do as well, or at least there are some questions that we can use as starting points for our teams. For example, how can we as system actors create more space for treatment hesitancy? Are we able to move at a different pace with some of our more ambivalent clientele, or do they have to just kind of get with the program? We can ask if our treatment partners are still the right fit for the evolving needs of our target population. Perhaps most of our participants are on medications and most of our treatment partners aren't able to work with medications. Perhaps it's time to revisit that list. For example, are we overusing inpatient treatment because that's what our primary contracted provider offers? Are we recommending one opioid medication over another simply because that's what we have access to? What about cultural fit? Are there religious aspects to the treatment we offer that isn't appropriate for some of our clients? And lastly, when we look at bird's eye at those treatment plans, is there a balance between one's clinical and social or cultural needs? Are we focusing too much on reducing use as opposed to addressing some of the social determinants of health in their life? Okay, so just to quickly review, through a harm reduction lens, treatment planning should always be as collaborative as possible. It's that meet people where they're at principle that we've heard so many times. Collaborative planning means that the goals are shared, they're not imposed, the modality is agreed upon, not coerced, and the metrics of success between the clinician and the person are aligned as much as possible. That's the North Star, and it's the approach that's also backed by research as well. Importantly, this approach isn't just about being nice, though. Oh, if you could just go back to the previous slide, sorry. Because people who've been around the block can see through us just being nice. If we're not listening and we're just coercing them in a friendlier way, they're going to see through that. They're going to see us as just the same as all the other system actors. So working collaboratively, developing that therapeutic alliance and trust, it just works better. It limits harm and helps people feel like they truly own their recovery. These plans usually take a little bit longer to develop and often requires us to slow down with our clients. They take a bit more patience and negotiating, but that's the work. And I'll just say from personal experience that nothing feels better than someone heading off to treatment with some measured enthusiasm and buy-in. We really can't control what happens next, but that's okay. And we've done our bit. So some other tangible steps, we make sure we're referring to culturally safe partnerships, if not a culturally specific option. We strive to have diverse representation among our own staff and leadership. We make sure our program has an outpatient group or phase for participants who are still in the contemplative stage. I mean, that really is, to me, the most important piece for retention and to just make sure that people are moving through recovery safely. And we make sure that treatment intensity and level of care is shaped by clinical needs and recovery science, not by the seriousness or nature of one's legal charge. We also want to make sure that both new and further along participants are not just thinking about their use, but also their social and cultural needs. As I mentioned, these things are what makes life busy and fun and fulfilling after graduation. That's not just final phase stuff. We want to think about this on day one. Drug courts we have time on our sides. So let's use that time and address some of these things on day one and see how they change over time. Next slide, please. So one thing that we do know is that, somebody's going to be in our program for 1 or 2 years and they're not going to be abstinent that whole time. And they're not going to be enthusiastic the whole time. In fact, they might even be using for most of that time. So with that in mind, I think we need to always asking ourselves, what are we doing to make sure that our clients are using as safely as possible, if that's still the case? Well, we can do that in a few ways, and that's outsourcing, education, and access. First, we get out of the way when it comes to addiction and psychiatric medications. We partner with expert prescribers and only those that we know will treat our participants with respect and compassion. We're not trained to tell our clients to use or not use a particular medication. That one is simple, but a huge problem in the field. It's not uncommon to hear practitioners say, our program prefers Vivitrol, maybe not so much in Canada, but often in the US. But some clients want the other medications. Anyways, we can't be doing that. That's borders on drug court malpractice. Second, all of our treatment providers should know how to support our participants both in abstinence and active use. In other words, they should be fluent in the drug set and setting model and able to educate clients on the unique risks of polysubstance use. We should be also providing clients with alerts about the current drug supply. And if these conversations aren't happening, we're only doing really half of our job. And third, access. Our clients, no matter where they're at in their recovery journey, using or not, should either have or know how to access naloxone, sterile using supplies, and drug testing kits. These are life-changing, life-saving tools, and it can be sometimes difficult conversations to have, sometimes uncomfortable, but pretending that these tools don't exist just enables and increases the risk of harm, not abstinence. All right, next slide, please. Thanks. Okay, so on to supervision. And so when we think about this component of the drug court model, we have to first acknowledge that by definition, there's not really a true equivalent of this practice in harm reduction. For example, there are no curfew checks or drug testing for the sole purpose of measuring accountability or compliance. So all we can really do here is use the harm reduction lens to help us rethink about this aspect of our work in a new way. For example, the harm reduction lens forces us to examine how our drug policies shape the way we treat ongoing use in the drug court context. Put another way, how does drug prohibition inform drug court practices? Well, almost unthinkingly, abstinence has become a proxy for compliance, and drug testing has become the most important accountability tool the model has. Not maybe every court, but most courts. And while that might seem to be a little bit reductive, if it wasn't the case, our drug testing practices would be radically different. They wouldn't be observed or randomized, and contested results wouldn't lead to sanctions or termination. Drug testing would be voluntary and used to help understand if the drugs being used are contaminated or contain unexpected excipients. So what does that mean for us in a practical sense? Well, trauma-informed drug testing, which is recommended by the American Society of Addiction Medicine, perhaps offers some middle ground. This approach to testing is designed to help assess treatment adherence, but is not observed or randomized, and therefore not designed to catch people being dishonest about their use. In contrast, this approach is not predicated on the idea that our clients are untrustworthy. It is far less intrusive and can therefore help limit the re-traumatization of those with existing trauma histories, which we know makes up most of our clientele. A second process or practice at odds with harm reduction, as AJ mentioned in the introduction, is the continued use of jail as a sanction. Though less frequently used than in the past, which is a great thing, jail sanctions remain a purely enforcement-driven practice. There's no evidence base for jail sanctions, and it's not considered an effective public health strategy anywhere except in the drug court world. We have research outlining the many risks and harms, but no research showing jail sanctions are associated with improved health outcomes. As such, the harm reduction alternative here is more clear. Stop using jail and expand our list of alternatives. All courts have a range of responses at their disposal, from increased clinical support or treatment plan adjustments to homework or additional court appearances or meaningful community service. It's just a matter of expanding these. Next slide. So just to put a final point on this, the numbers are clear. Jail is associated with an increased risk of overdose as well worldwide. That means that if we're still using them as a sanction, the burden is on us to prove that we have an evidence base behind it, not just anecdotes. And so if we're continuing to do this, the burden is on us to show that it's the safest approach available to us. All that said, drug courts, of course, are still by definition concerned with accountability and measuring change. That's how folks avoid their jail sentence. So we do still have that practical consideration. And that leaves us with some important questions. What would happen if we tried to make drug testing more trauma-informed? What would that look like? What message do we reinforce when we punish people for use? Does that message align with our program's understanding of recovery? What would happen if we stopped sanctioning use entirely? And what if we were prohibited from using jail as a sanction? What else could we use? Would our program become a safer place? And so just to summarize, a more harm reduction lens has us thinking about new ways to think about compliance. If someone commits an actual crime, treat it as such. If someone is struggling to meet every obligation in a drug court, treat it like the health symptom that it is. If someone isn't following through on a commitment because of their substance use, mental health, or social instability, we should be working to address those underlying needs, not criminalizing them, even indirectly. Accordingly, as practitioners, we need to be reflecting on the ways that we might be overstepping or overusing our power when supervising participants. We want them to understand boundaries. So of course, we need to model that and make sure that we're not overstepping ours. Okay, I'll pass it on to you, AJ.
Great. So the next point in the journey of a client's progress through treatment court is case management. So case management is, of course, crucial to the overall success of our clients. But what makes our work challenging is the systems that our clients and case managers have to navigate. Our clients in the high-risk, high-need population will have had to navigate and survive years of marginalization, like community divestment, housing policies, wage inequity, over-policing, and so on. And these systems have sent messages to our clients about their worth and value, and we're in a position to potentially have the opportunity to change that narrative. So harm reduction understands systemic neglect, again, in the form of these housing policies, unemployment, so on, to be the primary issue facing drug users. So unlike in treatment courts, where we typically center the clinical treatment for substance use disorder as our main intervention and consider other services to be complementary or secondary, harm reduction understands that if the conditions that the drug user is living under are improved through equitable access to quality services, their quality of life would drastically improve regardless of their drug using status. And a clear example of this is the housing first model, in which people in need are offered low barrier housing, regardless of their substance use or mental health or legal status. So instead of their housing being conditional upon their sobriety, housing is offered as a human right. And in addition to the material impacts that this initiative has had, providing services that are not conditional on someone's sobriety sends the message to folks that they deserve and can benefit from services at any stage in the recovery process, which can really strengthen our alliance with the client because they'll feel more able to come to us in times of need. So treatment courts should strive to work with partner agencies that provide this type of low barrier to entry services that are not conditional and can drastically improve somebody's life. To that end, we often also have really high expectations and requirements of our participants, despite being under-resourced ourselves and in our communities. So we also have to measure our clients' ability to meet the program's goals relative to what's available. And if we're overloaded as case managers, that's going to have an impact on our work. And in these cases, it's important to consider outsourcing some of that case management to other partner agencies in the community. So if you're not able to manage helping somebody apply for benefits, for example, it's important to find a different organization that can help with that, because connecting them with these types of services and benefits can have a really big impact on their lives. So some questions for teams. How can our court better account for specific health inequities? How can our court account for service gaps and our expectations of participants? Where are we going to reconcile that? What are the requirements of our partner agencies, and can participants meet them? Are we adequately staffed to provide comprehensive case management, and who might fill these gaps? And then opportunities for change. So partner with low barrier service providers, ensure that program compliance and progress is measured relative to the quality and availability of services, and develop a resource map to identify all the resources available, especially in underserved communities. Okay, and I see a question in the Q&A, so we'll circle back to that in a moment. Okay, so that brings us to the final part of the treatment court journey, which is graduation or termination. So since their inception, treatment courts have been relatively static when it comes to how success is measured. People graduate when they complete all of the program's treatment phases and meet all of its requirements, things like achieving 3 or 6 or 12 months of abstinence, paying off their fines and fees, having a house and a job, and having some kind of aftercare plan in place. And these are great, but they can be really hard feats to achieve, especially the payment of fines and fees, which often goes overlooked. That's something that Dave and I have seen over and over again. And phase advancement throughout the course of the program can also mirror some of these achievements. And while equal application of these measures can give people clarity about expectations, it also runs the risk of oversimplifying the recovery process, making it seem overly linear and one size fits all. So conversely, success within a more harm reduction oriented frame is a bit less rigid. At the individual level, success is defined by the person receiving services and reaching the goals that they've set. These goals might include a change or reduction in use, including sometimes abstinence, avoiding injury or infection, or simply surviving their next use. Several important measures of success for harm reductionists, however, are also shared by drug courts, right? So stable housing, income security, peer support. However, more can be done to prioritize and support other measures of success, like improved relationships, new connections in the community, whether it be recreational, religious, or spiritual groups, also improved physical health, and even the obtaining of documents like personal identification documents or child support payments. And uplifting these other points of progress can help our clients see all that they have to offer in addition to their sobriety. So our courts can consider having more flexible pathways towards both phase advancement and dignified program completion, even when a participant might not meet every single graduation requirement. For example, if someone's been in the program for over 18 months and their quality of life is stable and has improved, but they occasionally use substances, how can we provide this person with a non-custodial option for completion? How can we safety plan with them around overdose risk and aftercare and uplift all of the progress that they've made? So some questions for drug court teams. So the first one is, in what ways can we limit the destabilizing impact of phase demotion? So in addition to phase advancement, sometimes drug courts resort to phase demotion, which can be really destabilizing. How much does our court value other markers of success beyond abstinence? Are fines and fees prohibiting participants from graduating? How might our measures of success be more fluid and flexible? And do our graduation ceremonies place emphasis on substance use over other achievements? So these are really a starting place. And then some opportunities for change. So ensure that graduation criteria includes broader health and social outcome, again, like new hobbies and improved relationships. Explore non-custodial pathways for completion. Review existing graduation criteria against dropout and termination data. And program graduation should not be contingent on, again, the payment of fines and fees. Okay, and with that, I'll pass it over to Dave, who's gonna just wrap us up.
Thanks, AJ. So just so we have enough time for Q&A, I'll just say this, a few things as a final point here. Obviously, you can as practitioners take or leave whatever we've offered today. But I just wanted to kind of point out that some of the things that we hear doing this work at kind of a national level is that frustration levels these days are high. We also hear about participant retention levels being low. And then we also kind of just hear kind of indirectly in the way people talk about their participants, kind of like an us and them culture. And I really think that harm reduction, harm reduction isn't a solve all. It's not a silver bullet, obviously. No one would really, I think, assert that. But I think it can help with each of these things and break down each of these issues, because it really is about relationship and connection and mutual respect. And really listening to what people's needs are and whether they're communicating them directly or indirectly, and just kind of bringing the staff and practitioner and participant in alignment. So if it feels like you're struggling with one or all of these three things, I really do think that integrating harm reduction, the principles and practices, could go a long way to address and resolve some of those tensions. So I just wanted to kind of add that as a final point. But we've got just enough time, I think, to address some questions here that we have, which are really great. The first one is about housing. AJ, did you get a chance to read that? Do you have any thoughts on that?
So I'm not sure if everyone can see it. Maybe it's unclear to me, but the question is how to get landlords on board with low barrier to housing. We've had many landlords pull units from our addiction supportive housing program due to damage, drug trafficking, etc., out of units, and now our housing stock is low. Landlords no longer want to rent to our clients. And that's a great question that I think it's a challenge. Dave, I don't know if you have any particular thoughts around that. It's something actually that we've heard recently when we kind of proposed this in New York State, that I think this is happening around New York State as well.
Yeah, I think, I mean, it's an excellent question, because I think even offering what we kind of consider harm reduction or housing first or low barrier housing, it's something that we have to do, but it doesn't come without its challenges. Often when we're housing that particular group, it's a group that hasn't maybe had housing in a long time. It's a group that doesn't necessarily maybe their social network also hasn't had housing, so they're often housing their friends and housing their community. So that doesn't make it easy for them to necessarily kind of have control over that space. So I've seen that personally as a practitioner, the challenges around that. But I think we can kind of just impose this harm reduction framework on this. And we say, well, if the traditional view would be like, well, if they can't take care of their space, they don't get it. But that doesn't really help anybody. So I think the other way of looking at it is, what's everything we can do? Given the challenges, what's everything we can do to support that person before they get their housing, when they get the housing? How can we advocate for them to keep the housing? What kind of support can we provide them, kind of just in terms of life skill education, and the value of what that housing does in terms of, you know, just our day-to-day counseling with them? And then what can we do with our housing partners in preparation? I know this is kind of like maybe too little too late in some cases, but in preparation, when we develop these partnerships, to say, these are some of the things that can happen. This is the way we're going to try to support you as much as possible. We don't expect you to bear the brunt of all of these concerns, but we're going to try to do our best to make sure these things don't happen. Some of this is unavoidable, but that's kind of the world of harm reduction. You're just trying to look at all the different ways you can be an advocate for your participant, but also give them the skills to make sure that they hold on to things that are so important. And so stabilizing, like housing. But it's a great question, and I think the best way to also address it is by having a spectrum of housing options, so that some of the housing is kind of matches the needs of, you know, different populations that you're trying to get off the streets. There was also another good question about pushback that we get when it comes to redefining success. That when we're presenting on this particular topic. AJ, do you have any thoughts on that?
Yep, sorry, I just was catching up in the chat. You said the measuring success question, right?
Yeah.
Yeah. So the question is, what's the biggest criticism you receive in presenting this approach around redefining success? And then the follow-up says, do you have any recommendations for measuring success tools? And actually, that is the biggest question that we get around this recommendation, is how do we measure these things? And so Dave and I are doing some work around opioid courts, which are much less defined. That's a model that's new. And so we've put our heads together around different types of checklists that folks could use just as a way to open a conversation with participants around these different things that I was talking about, around improved relationships, physical health, things like that. But this is going to be a situation that's a lot less rigid and harder to measure than traditional things like months of abstinence that we know through drug testing and things like that. So Dave, I don't know if you have anything else to add about that, but
I would just add that part of this has to be kind of addressed indirectly by shifting the paradigm away from just kind of the inherent criminality of drug use. And if we start to see, you know, that, and this might seem counterintuitive compared to everything else we said today, but you know, in the drug courts are also about recidivism, about criminal activity. And if somebody is not negatively affecting community safety, and they're not involved in the justice system, but they're still using here and there, I mean, drug court's kind of done its job. Drug courts are not just in charge of making the world sober, right? The drug courts are also are about making individuals and the community both safer. And if you can make the point in a clear-cut way, no new charges, the person's been complying and doing their best in every other way, I think it's easier to make a case. But the challenge in a lot of contexts is that drug use itself is so still, you know, stigmatized and so heavily criminalized in the language used, that it can be hard to think about success in as existing alongside ongoing use. So I think it's not always going to be easy to do this, but slowly, as you develop cases, you see certain people do really, really well and make important improvements in their life, but they you know, not necessarily completely abstinent. You want to hold them up as kind of examples and say, like, it can be done. And this is a success for us too, not just the participant, but we've done a really good job with a person who might not be absent for the rest of their life, but they're not going to be in jail. They're not going to be on the streets. So we want those as examples because that's good for us too. I think it shows that we know how to support people even if they can't meet certain strict requirements. But we need those kind of case studies to kind of prop up. I hope that hope that helps. I think it's going to be a slow process in some cases though.
And just wanted to add one quick thing, which is that something that Dave and I talk about often is how the early months of the COVID-19 pandemic really had drug courts, at least in the United States, really rethink drug testing in particular, and how they might move folks through phases and graduate people while they weren't able to rely on drug testing as a tool. And so they often kind of relied on their clinical intuition or their alliance with participants to make those decisions. So we would also encourage courts to think about how they might gain some of those or use some of those lessons learned from those days when you didn't have all your traditional tools in the toolbox.
Yeah, and absolutely. And I would just add to that anybody that's been in this business for a while, you tend to know when your clients are using. And even if they do slip in a use here and there, and maybe that goes undetected, these things tend to kind of work themselves out. It's not the ideal, but what we want to focus on just as much is, as AJ said, have we built that trust so that we're not so concerned about whether or not somebody is disclosing honestly, but have we as practitioners, as system actors, created such a safe space that disclosing use actually is easy? Because if I have a client and that this person doesn't want to tell me that they've used, well, that's some of their stuff, but it's also some of my stuff maybe. Maybe I've propped them up too much for their long extended period of abstinence to the point where they think I won't feel the same way about them if they've used. So it's a give and take. And I think it's a clinical issue, but I think it's also a cultural issue from all practitioners in the court. And we want to make sure that we are propping up our participants for all of their small successes, not just for what's showing up in their drug test. And I think over time, we'll see less and less importance placed on what comes back in the drug test in terms of it being kind of the primary measure of recovery and improved health. That's my North Star, at least. Yeah.
So I think we're at time, but there is just one more question. Maybe we can
go for it.
Quickly address. Okay, so there's one more question. It's, can you provide more information on trauma-informed drug testing? What would that look like? And I know Dave has given that a lot of thought. If you want to answer that one, Dave.
Well, I think the primary is first off, try to get away from observed testing. So we're seeing more oral swabs being used now to try to test. There's some different limitations to that, but again, there's nothing's going to be perfect. Even urine testing isn't perfect. So I think the best thing to do is to first think about, what are our medical professionals saying about the potential to re-traumatize by somebody having observed drug testing. People who have experienced sexual violence and people with PTSD have studies have shown that observed drug testing can be re-traumatizing. So anything we can do to move away from observed testing, put a little bit more trust into the participant, and just kind of, again, shift the culture and the paradigm away from this idea that we're catching participants and just use it as a measure of like, this helps. Hopefully this is used in a way that helps them as much as us kind of gauge how things are moving along. Some participants are going to want drug testing. I've had drug test participants tell me that it's helpful for them. So let's just make sure that it's only helpful and not inadvertently harmful as well. But I think moving on to something like oral swabs, is probably less demeaning than having somebody watch you, provide a urine screen.
Great. Well, thank you, everyone. Thanks for having us.
Thank you to both of you. If I could just take a second, it's been really eye-opening and inspirational as well to listen to the work that you've been doing and the presentation. I have to say, from my perspective, I'm a provincial crown, so the equivalent in the States to an ADA, and it really turned my mind to how much more we can work in collaboration with our community partners and the other members in the justice system and part of our team. Because I think you made this point, Dave, where you said that the clients can really see through us. And that really stuck with me because if we're not being genuine in our intentions and how we, if we're not being genuinely kind towards them as opposed to having an ulterior motive, they could see through that very easily. So that was a really big take home for me. And thank you for that. It's been really great, like I said, and I'm going to watch this on repeat a few times. So thank you very much for your time. And if I could just close out for the day, thanks to everybody for attending. Thank you to all of our panelists, moderators. Everyone today it's been great. For people who are able to, we hope that you join us again tomorrow for day 3 of our first annual conference. And it may be helpful if you delete the link in your inbox for day 2 and probably day 1 so that you don't get confused about which link to push for tomorrow. That would be really helpful. One of the questions that we have had pop up is, when are these panels or presentations going to go live? Once we figure out the logistics of that and get permissions that we need to get, we're looking at about maybe late next week or early the week after. We'll be able to post them on our website, which is justicetreatment.org. And we hope to see you tomorrow. This has been great. We really appreciate the feedback, and we hope to see you tomorrow. Have a great night. Be well, everybody. Bye-bye. Erin, I can push stop recording, right?
Yeah, go ahead.
Okay, thanks.